one check written and I can't get it filed. Anyway, I just had to vent a little bit.
Okay.
I'm sure we'll work it out, but
We're pretty close.
does anybody even look at these, by the way?
All right, we are back for our second half of the Corporations Committee. We are continuing our discussion of the subcommittee's working group on LLCs and business fraud. We are on Senate file, or sorry, I already made this bill a Senate file. We're on 25 LSO 115. Providing false information to registered agents. We've heard from the Secretary of State's office. I know where we are, our working group members back in the room. I know Mr. Meyer had to leave, but Mr. Weaver, Mr. Pope. Okay. And there's Mr. Pope. Welcome back. And is Senator Barlow in the room? Okay. All right. Well, we'll just continue moving through public comment. Go to the other members of the working group. Mr. Pope, did you have any comments you wanted to make on Senate file or on working draft 115?
Thank you, Mr. Chairman. I don't have much in the way of comments. I have a little background noise right now, so please forgive me. About the only thing that I would like to comment on is that whenever there's a dissolution, that there are terrible consequences for the shareholders, members, or of any entity that's dissolved on the state level. These are mainly federal tax compliance issues, and they truly are significant. And so, if there is a rulemaking process, if this were to pass and there's a rulemaking process, I would really, I would recommend highly that this be a very considered approach, or the rulemaking be very considered on this by the Secretary of State's office, and there be opportunities for mitigation and correction of stuff that might be incorrect within the registered agent's files. That's really the only comment I have, and I'll stand for questions.
Hey, any questions for Mr. Pope? No? All right, thank you, committee. Moving into some general public comment. Do we have any public comment in the room? No? What about in our virtual world? Any hands raised for public comment? Now would be the time to raise your hand or let us know that you want to come into the room. Nothing? All right. We'll go ahead and close public comment on this bill. Committee, what is your pleasure? You want to move this forward to the next meeting? Just like we did the last one, got a motion from Representative Haroldson to move this bill forward to our next meeting, and a second from Representative Ottman. Any amendments you want to make before you see it advance? Any discussion? No, all those in favor signify by saying aye. Aye. Any opposed? All right, that motion is carried. Next up, we have 25 LSO 116, foreign adversary government ownership of business entities. Ms. Adams, is this you?
Yes,
All right, take it away.
this is 25 LSO 116, working draft 0.3, foreign adversary ownership or control of business entities. So what this bill draft does is it amends the grounds for administrative dissolution, revocation, and forfeiture to include foreign adversary ownership or control as specified. And so this is going to look very similar to the prior bill because it's going into the same set of statutes and providing the Secretary of State with a similar authority to administratively dissolve and terminate business entities, but on slightly different grounds. So the Secretary of State, you can see on page 2, I'll just go through this one. The Secretary of State may commence a proceeding under 1421 to administratively dissolve a corporation if any of the following has occurred. And so under paragraph 6, it's in the public interest and the corporation. And then moving over to page 3, subparagraph D, is owned or controlled by a foreign government or foreign non-government person determined to be a foreign adversary by the United States Secretary of Commerce and specified in 15 CFR 7.4A. For context, that language is modeled after the recently enacted critical infrastructure statute. And so it pulls that language from what's currently in statute and that was passed. And in 15 CFR 7.4A, the U.S. Secretary of Commerce designates China, Cuba, Iran, North Korea, Russia, and the Maduro regime in Venezuela as foreign adversaries. Moving to pages 8 to 9, there's a similar staff comment as the previous bill identifying the business entities whose statutes are amended. And then there's an additional staff comment starting on page 10 that explains where the language is modeled after. And then it also has some areas of consideration for the committee. And so one big area of consideration is whether to define what it means for a foreign adversary specified in 15 CFR 7.4A to own or control a business entity, or whether to use some sort of different terms to make that determination. So you'll see some sub-bullet points, and those provide some examples of language from federal statute and regulations. So the Committee on Foreign Investment in the United States statute has a definition of control, and that's set forth there. There are also CFIUS regulations that define control, and that's a long definition that goes on to page 11. And then there are also some regulations from the Department of Defense acquisition statutes that define effectively owned or controlled. And so that definition is there as well. Moving on to page 12, there's sort of a question about whether or not the committee might want to create a new statute prohibiting foreign adversaries specified in 15 CFR 7.4A from owning or controlling business entities. There's also a question about whether the Secretary of State should have discretion or be required to seek administrative dissolution in these instances. And I think some of that staff comment is based on sort of a question about what the extent of the Secretary of State's investigatory authority is. And then the final note there is whether to include an exception for situations where the controller ownership has been approved by CFIUS. And that segues into the legal memorandum that you've been provided that talks about this bill draft and one potential legal concern or consideration regarding this bill draft. And Mr. Chairman, I'm not sure how much detail you want me to go into on this. It's been provided to the committee and the public. It really talks about a potential preemption concern about this bill based on the Committee on Foreign Investment in the United States, known as CFIUS, and sort of their authority in this area.
Why don't you at least give us the high-end overview of that memorandum?
Sure, Mr. Chairman. So this first page of the memorandum just sets out a summary of the bill draft, and then it notes the supremacy clause of the United States, which provides that the supremacy clause of the United States, laws of the United States shall be the supreme law of the land, notwithstanding state law to the contrary. And Wyoming Constitution has a similar provision. And so because the laws of the US are the supreme law of the land, Congress can preempt, meaning invalidate a state law through federal legislation. And so there are three different types of preemption: express preemption, where it's expressly stated in the federal statute, field preemption, and conflict preemption. And I think this bill implicates the Committee on Foreign Investment in the United States, known as CFIUS. And so that statute is found in 50 USC 4565. And so on your memo, pages 2 through 4 provide a summary of sort of an outline of what CFIUS does and what authority it has. And so I think the main concern there is that it does review what are referred to as covered transactions to determine their effect on national security and take any necessary actions in connection with a transaction to protect national security. Page 3 has a definition and sort of an outline of what is considered a covered transaction. So we have mergers, acquisitions, and takeovers that's proposed by or with any foreign person that could result in foreign control of a United States business. We have other types of investments, and we have changes in the rights of those foreign persons. And the applicable definition of foreign person is broad under the federal statute. So it means any foreign national, foreign government, or foreign entity, or any entity over which control is exercised or exercisable by a foreign national, foreign government, or foreign entity. And you do have the definition of control there from the CFIUS statute. And so this memo explains sort of how review can be initiated. And then it talks about the different action that this committee at the federal level can take, including suspending a proposed or pending covered transaction while it's under review for national security concerns. They can negotiate and enter into or impose and enforce any agreement or condition with the party to the covered transaction to mitigate those risks to national security. They can refer a covered transaction to the president, and then the president has authority to take certain actions regarding that. And so CFIUS may be familiar because we saw it implemented or how it worked with the Mine One Partners Limited operation near Francis F.E. Warren Air Force Base. So I think although the CFIUS statutes don't contain an express preemption provision, a question could be raised about whether or not there's an implicit preemption. So in prior conflict preemption cases, there's been some discussion about sort of this overlap between state law and foreign interaction with foreign governments and that sort of foreign realm. And then we've also had some recent legislation regarding the Florida statute regarding foreign ownership of property. And so that's described in the memo as well. And then also some of the CFIUS implications related to TikTok and the Montana bill that banned TikTok within the state of Montana. And so given the cases and the preemption principles, one question is whether or not the authority of the Wyoming Secretary of State to dissolve, terminate, or revoke the authority of a business entity could directly conflict with a prior approval by CFIUS. So CFIUS might approve a covered transaction that results in a business entity being controlled or owned by a foreign government or a foreign non-governmental person that's specified in this bill. And that approval might involve an agreement or conditions to mitigate risks to national security. And then despite that approval, the Secretary of State would have authority to dissolve, terminate, or revoke the authority. So it could be argued to stand as an obstacle to CFIUS in that federal statute. And there's a suggestion on page 7. If you wanted to avoid that direct conflict, you could carve out an exception for ownership or approval of ownership or control by CFIUS. And then another question is, even where CFIUS hasn't reviewed a covered transaction, whether or not a decision to administratively dissolve, terminate, or revoke the authority would nevertheless interfere with the objectives of Congress with respect to foreign investment in the United States businesses. An argument could be made that any concerns about foreign control or ownership of business entities should be referred to CFIUS in the first instance before making a decision to terminate. And I think a counter argument could be made that where CFIUS hasn't conducted any review, the state is entitled to fill those gaps to protect its interests and its citizens. And obviously LSO cannot predict how a court would rule on this, and it's a complicated area of law. And so this is just some considerations for the committee.
Thank you, Ms. Adams. Anything additional on the bill or?
No, Mr. Chairman.
All right, committee, do you have any questions on the memorandum or the bill? Senator Landon?
Yeah, so sort of an elementary school question, which was, what was the desire of the working group with regard to this bill? Everything that Ms. Adams just shared with us, which was a lot. If we want all of that to come into play, I'm just trying to get arms around how we're going to get this bill to the finish line. This could get really big. So I'm just wondering, is the working group comfortable with just going this far? Or what do we want to do with all those suggestions?
Mr. Secretary, do you have any comments on one, the genesis of this in our group, and then
Yeah.
two, going forward?
Well, Mr. Chairman, is there any chance I could just go through our comments? I think we're going to address a lot of those things.
Sure. Are there any other questions for Ms. Adams? Let me
Yeah.
get any other questions.
Okay.
Then we'll circle back to yours. Yours is kind of a big question.
And we're going to
so-
address the memo in our comments.
Okay.
Yeah.
Representative Yin?
Mr. Chairman, thank you. Katie, so maybe we have to edit the previous critical infrastructure bill as well, because I was trying to, while doing research on the bill, I was looking up the CFR, and the CFR actually changed on July 18th, which clearly isn't your fault, but they actually moved that section to a different section. Is there any language that we have in statute that says any successor regulation or anything like that, or would we have to explicitly change it?
Ms. Adams?
Mr. Chairman, Representative Ian, I think we would have to explicitly change that.
So, Mr. Chairman, for the committee's edification, CFR is the rules version for the federal government, so their administrative rules. And so they can change it basically by executive order anytime they want. And us putting it in statute, referencing a specific section of the CFR, maybe if we do it at a specific date or something, but we run that risk of it going out of sync.
Or do we need the CFR citation at all? Could we just say something like commence and specified under federal law?
Mr. Chairman,
Senator Scott?
Mr. Chairman, in response to that, in quite a number of areas in the health area, we used to say thus and such federal statute or subsequent similar federal enactment. We modify that slightly to deal with regulations, specific federal regulation or subsequent similar federal regulation. But that's how we handled it for years in the health area, and you'll find that in a number of places in the statutes.
Thank you, Senator Scott. Very helpful. I think that is an easy fix. Any other questions for Ms. Adams? All right. Mr. Secretary.
Well, thank you, Mr. Chairman. Really appreciate the work of the working group and the committee. And 25 LSO 116 was a solution identified by our office concerning the real risks that foreign adversaries such as China and North Korea could be utilizing our business formation statutes to conduct business in Wyoming. And I want to emphasize that this really is needed. Although our office has instituted the administrative dissolution process for false and fraudulent documents filed with our office, existing statute does not allow our office to administratively dissolve entities that are owned or controlled by foreign adversaries on their face. Now, earlier this year, we encountered a situation in which entities controlled by North Korea were found to be operating in Wyoming. In close consultation with the FBI, and after our own thorough investigation, it was discovered that the entities in question could be administratively dissolved because of filings they made with our office. Frankly, I believe this is a huge loophole in our statutes and one which should be corrected. This bill draft directly addresses this issue by allowing our office to administratively dissolve entities that are owned or controlled by a foreign government or a foreign non-government person determined to be a foreign adversary by and there's the CFR citation, 15 CFR 7.4A. Now, in terms of the LSO memo concerning the possibility of preemption, I want to make a couple points. And look, I know we've got aficionados of LSO memos in the legislature, and I'm a former member. You know, that these memos get written, and it doesn't mean LSO is taking a stance one way or another. They're just raising these issues. And I truly feel that we are fine with this bill in terms of any preemption issues for a couple different reasons. First, as the LSO memo states, Mr. Chairman, there is no express preemption, meaning there is no explicit federal statute which is in conflict with the state administratively dissolving a state chartered corporation or limited liability company or any creature of the state. And that's what these filings are, creatures of the state. The LSO memo does not identify any conflict between the bill draft and federal law, only areas of federal silence that this law addressed. The LSO memo did discuss a number of pending cases from other jurisdictions in which I would say one of the biggest distinguishing factors, again, from some of the cases highlighted in the LSO memo is that this power is specifically dealing with a state charter. And that is a big distinguishing factor. Now, to further elaborate on this, I want to turn this over to our counsel, Joe Rubino.
Mr. Rubino?
Thank you, Mr. Chairman. Yeah, if I could add a little bit more to that, I think the LSO memo provided a really good starting place, especially with identifying a couple of the U.S. Supreme Court cases, which I think are very distinguishable, and then a couple of the cases that are currently pending in other districts. One is in the 11th Circuit right now. I believe that oral arguments were heard on that one in April. That's identified in the LSO memo. That concerns the Florida bill regarding foreign land ownership. The other one is in the 9th Circuit that concerns the Montana bill banning TikTok. And neither of those bills, first to take a step back, when you dig into the briefing, the pleadings, and the district court decisions granting either preliminary injunctions or their decisions before they were on appeal, they all dealt with this. They all cited to a lot of Supreme Court cases terminating in this Crosby case that's identified in the LSO memo. The Crosby case is brought up in a number of instances, just from a really high level, that dealt with a Massachusetts statute that implemented sanctions on foreign governments. And clearly there was a preemption issue there, right? The state of Massachusetts was engaging in the leveling of sanctions, something that we all know just anecdotally is something that we really think of as being a federal government duty, something that the federal government does in interacting with foreign governments, things like sanctions, tariffs, embargoes, things like that, dealing with foreign trade. In some of these cases and in the pleadings, you see that ferreted out in terms of the debate is whether or not they really fall under that case, and that case is holding that a state statute was found to be preempted, whether or not it was historically a power of the federal government, such as leveling sanctions, tariffs, things like that, or something that was historically part of the state's police power. With these foreign land ownership bills and the bill regarding TikTok, I think those are very distinguishable from this case. Certainly TikTok, they just want to ban TikTok's existence in the state of Montana. With the foreign land ownership, that interferes with contractual rights. That gets into an entirely different argument. The LSO memo didn't highlight it in my own research. I also could not find any bills that were challenged under the supremacy clause that dealt with historically state powers, such as the police powers of the state, powers that were not expressly enumerated to the federal government and that fall historically to the states. Just in looking at what this bill would affect, it wouldn't affect transactions that would be under CFIUS or anything like that. Administrative dissolutions, as we've been talking about this morning, conceptually deal with revoking a state-granted charter to private entities, right? And that has always been at the state level. It's enshrined in our state constitution. I mean, in Article 1, Section 30, corporations being creatures of the state endowed for the public good with a portion of its sovereign powers must be subject to its control, meaning the state's control. Article 10, Section 1, the legislature shall provide for the organization of corporations by general law. All laws relating to corporations may be altered, amended, or repealed by the legislature at any time when necessary for the public good and general welfare. And all corporations doing business in this state may as such business be regulated, limited, or restrained by law not in conflict with the Constitution of the United States. And Article 10, Section 2, control by the state. All powers and franchises of corporations are derived from the people and to be granted by their agent, the government, for the public good and general welfare, and the right and duty of the state to control and regulate them for these purposes is hereby declared. So that was some of my initial research. And I think, again, the LSO memo is a really good starting place, and it highlights that there's no express preemption with anything in either the federal constitution or certainly the federal constitution or any federal law or regulation. I do want to note just one clarification because I get it from the LSO's memo. It does not interact in any way with anything that would be recommended to CFIUS or anything like that, nor would it prohibit anything that would be an action taken either by the committee or under the regulations, a recommendation that it then results in a formal action by the president, as we saw with the Mine One transaction. All this does is it revokes or administratively dissolves a state charter to a corporation, a limited liability company, something that is a creature of the state. And so I just wanted to make sure that that was flagged. I think before we look at, changing it in any way, I think there are a couple of really, really big key differences between this and some of the laws that are being challenged and that, frankly, the states are really pushing back on it. I mean, you see with the amicus briefing in the 11th Circuit case, it was an amicus brief. It was filed by, it wasn't by Wyoming, but it was all the states surrounding Wyoming. And we had Idaho, I could pull it up here, but numerous states that, at least in the real property context, which is different from this because there's nothing that's being granted by the state, there was no preemption concern with that. So I'm happy to answer any questions, but.
Senator Scott, did you have your hand up?
Yes, yes, Mr. Chairman. I
Go
must
ahead.
say I was impressed with the LSO memo, and I'd like to try on the Secretary of State's office a remedy for some of the issues that are raised there that would have the effect of giving them the power to cooperate with the federal government. And I think that might be a way to solve our problem. So, Mr. Chairman, if it's all right with you, I'll propose a possible change that would recognize the federal authority. And we all know that the U.S. Constitution has given the federal government powers in dealing with international relations, and I think we'd be consistent with that. So what I would suggest, and if you look in the bill on page 3, and the other provisions are very similar, but if you put in after the new language on page 4, language that said, see, it says foreign adversary by the United States commerce and specified in the CFR, you said, then say, and an appropriate federal entity has requested that the entity, either individually or as a member of a class, be prohibited or restricted from doing business in the United States, and put a period then at the end of that. My thought is that would give our Secretary of State the ability to cooperate with any federal government entity. And this whole section is a Secretary of State may. So it would give him discretion as to which federal entities were appropriate and how to respond, because we don't know exactly how the federal government will proceed. But that would give him broad discretion if there is a federal request. So that would give us a law that allows him to, but make sure that he's cooperating with the federal government, which controls our international relations. So I just throw that out and would like the Secretary of State's reaction to that kind of a concept.
Okay, Mr. Secretary.
Well,
do you
Mr.
have a
Chairman,
response?
thank you. And Senator Scott, appreciate your comments. I will say, I just don't think that addition is really necessary. I mean, I think, encapsulating our response to the memo is that while we appreciate the LSO raising these concerns, that really they're not problematic, again, because this is enacted under a state charter and our Constitution and our body of laws going back to our nation's founding reserves this power to the states because it's a state charter. And, I would politely push back a little bit on the notion that it's conducting international relations in any way. This is just us pulling back something that is a state charter pursuant to our constitutional authority. I mean, as Mr. Rubino said, Article 1, Section 30, corporations being creatures of the state endowed for the public good with a portion of its sovereign powers must be subject to its control, unquote. And those other two citations are instructive as well. I won't read them again, but there's nothing, again, prohibiting us, as Mr. Rubino said, from reporting to CFIUS as well. There's nothing prohibiting any entity from the state from doing that. But to say that we need to get permission from the federal government to shut down something that is subject to a state charter, I just don't think is consistent with the federal Constitution, our state Constitution, our body of law, and the history of the way business incorporations have been done. And I think that the distinguishing factors on the case law that's cited in the memo, which Mr. Rubino, I think, did a good job of laying out, are really instructive in backing that up.
Senator Boner.
Thank you, Mr. Chairman. Just a little bit more on that concept, whether what Senator Scott specifically proposes is viable or not. It seems to me, especially in this situation with the last May with the North Korean entities, that it was the FBI that contacted your office, right? It's not, I mean, so does the Secretary of State's office have any capability of determining, what is a bad actor, what's being used as a front for these adversarial nations, and certainly, and as another question associated with that, do you look at any entity that may be associated with, say, Russia, China, as a threat, or would there have to be some additional investigation? Just a little bit more information as to what you all do on your end versus what we hear from our federal partners.
Mr. Secretary.
Well, Mr. Chairman, yes, it was the FBI that had sort of flagged these. Now, the notion that I'd have to then get permission from the Secretary of Commerce or whatever to dissolve them, I don't think we ever would have gotten that. But the FBI did raise these issues, and I want to underscore the gravity of it. I mean, they laid out that these are probably fronts that were funding the North Korean missile program. And I want to qualify that a little bit, but that was in our conversations what they said was most likely what was going on there. Now, I mean, I think we'd engage in fact finding on any entity that we received a complaint on. Counsel, do you want to maybe elaborate a little bit on the second half of that question on the process part of how this would be implemented?
Mr. Rubino.
Mr. Chairman, Senator Boner, absolutely. And just to provide a little more color on that, it was exactly as Mr. Crossman and the Secretary have pointed out at this meeting and in our meeting in April about how the process of administrative dissolutions work, right? Nobody can just come off the street or send us an email or give us a phone call and say, hey, I think that they filed a false or fraudulent document. I think that you should administratively dissolve them. No, we cannot take action with that. It wouldn't be prudent and it wouldn't be in accordance with the law. We do require them to file a sworn affidavit under penalty of perjury. If they file it with our office and there's anything untoward, meaning anything that is false or fraudulent with their affidavit, they've just committed a felony because they filed a fraudulent document with our office themselves. in saying this. The same is true for our federal partners. The FBI did approach us, and it started out as a conversation. We have, a lot of conversations with them, not just about foreign actors, but about interstate fraudulent actors that are having fraudulent operations in every state, not just Wyoming. And so we routinely engage with them on taking action on that in consultation and in coordination with them. What they did with this is they said, hey, look, we're reaching out to you. We're in the stages of our investigation. We want to loop you in. We had several phone calls with them and written correspondence. And then they gave us an affidavit, just like anybody else would, that detailed the facts indicating that this was a foreign actor. And they said to us, well, there's certain actions we can take as the federal government, but as the federal government, we cannot revoke their state charter. So what you do, it's up to you. And we said, well, okay, I mean, we would like to, because it was very clear from the sworn affidavit from the special agent that there were at least three North Korean entities operating under state charters, but our existing law did not allow us to do anything unless there was a false or fraudulent document with our office. We gave all this information to Mr. Crossman, and it turns out that they did file false and fraudulent documents with our office. But on the off chance that they didn't, or that they had retained a commercial registered agent or an organizer or a DC or New York law firm to fill this paperwork correctly, without anything to the contrary, we would just have a North Korean entity that would be operating under the banner of the state of Wyoming. Something that I just want to clear up, because I think it's been brought up, but I just want to be really explicit. Nothing in this would prevent transactions from occurring within the United States, nor would it prevent them from going and seeking a charter from another state. If a state, Colorado, Utah, New York, you name it, would like to be a mill of foreign adversaries that, are behind some of these limited liability companies or corporations, there would be nothing in this bill that would prevent that. It's just revoking the state and, the state apparatus from Wyoming. So I'm sorry, I know that was kind of long-winded. I hope that answered.
Senator Boner?
Yeah, that was good information. I'm not quite sure, forgot my question. I'm just generally trying to understand, the kind of the flow of information. It seems like it's very likely, if not always, going to come from the federal government. You'll get tipped off just like this situation we had a few months ago. So I just want to see, do you ever envision a situation where on your own initiative, the Secretary of State's office, you go out and identify these entities as being used as a front for our adversaries?
Mr. Rubino?
Mr. Chairman, Senator Boner, I'd say it's likely that it would be in consultation with our federal counterparts. I mean, I don't know what type of information that would be brought to us. Certainly they'd be looped in for sure.
Representative Yin?
Mr. Chairman, thank you. To Mr. Rubino, I do agree with you that this doesn't have the same issues of land ownership that we've had in some of the previous bills that we've seen. However, I do wonder if we do need a CFIUS carve out, because in Ms. Adams' memo, it talks about how CFIUS reviews covered transactions. Covered transaction includes any merger, acquisition, or takeover that is proposed by or with any foreign person that could result in foreign control of any United States business. So, for example, I have a Wyoming business. I sell it to a company in a foreign adversary. And then the Secretary of State, CFIUS, ends up approving the transaction. For some reason, they get a review and they approve it. And then the state decides to dissolve the business. Does that business have a court case? So that's the example that I'm trying to see if whether we need the carve out or not. Do they have a court case to sue the state if we dissolve something that CFIUS approved?
Mr. Rubino?
Thank you, Mr. Chairman. Representative Yin, I don't know if I'd have an answer to your question. I mean, whether or not they would advocate for that, it may be up to them. Again, I would go back to, this is a state charter that would be revoked. So if they wanted to go have a covered transaction and have it underneath the banner of another state, I don't see how anything would prevent that.
Representative Yin?
Mr. Chairman, so I mean, I don't know because I'm not a business lawyer, so I don't know whether us forcing the dissolution of a business that CFIUS ended up approving would violate a supremacy clause, right? Because as Mr. Pope said, that there are real consequences to a business being dissolved. So are we harming that business by forcing them to move to another state, even though they've been approved by the federal government?
Mr. Urbino?
Thank you, Mr. Chairman. Representative Yen, and I think that's just a classic example of federalism at work. I mean, I think that they're two different buckets. This does not interfere with any transactions. It does not invoke CFIUS, nor does it get in the way of any CFIUS approval. I think this gets back to a little bit of what we were talking about earlier in the interaction between our state and an entity, and the entity and its shareholders or other private entities in terms of mergers that they have. The federal government does have, under those regulations, under CFIUS, the ability to get in the way of those. We saw that with Mine One. But to my knowledge, I haven't seen CFIUS being imposed on interacting with between the state and a private entity.
Other questions, committee, for the Secretary of State's office? No? All right. Thank you. We'll move to, hold on. Did you have a question for the Secretary of State's office, Senator Scott?
Yes, Mr. Chairman. And that.
Sorry, go ahead.
That regards this business of who the foreign entity is and the foreign adversary. And I can see fairly easily where what you're dealing with is something that the foreign government itself owns, but where it's owned by a private individual that may or may not be an agent of the foreign government. How do we distinguish between one that clearly is just doing the bidding of his government and, say, a foreign individual who is really seeking to get out of the foreign entity or protect some of his assets from his own government and was coming in for those kind of reasons? Does this bill give the Secretary of State the ability to distinguish there, and how would he do it?
Mr.
Mr.
Secretary?
Chairman, I think I'll take an initial, give an initial answer, and then also would want to turn over to council as well. But I think it would be a case-by-case fact-finding mission, which we do all the time in investigating these dissolutions, especially with us, in executing this provision in statute that we can dissolve under certain conditions, which we really started executing in early 23. Now, granted, we've laid out how this bill fills in some loopholes in that statute, but we've gotten, I think, pretty good at engaging in these fact-finding exercises and distinguishing different situations like the one that you just laid out. Mr. Rubino, with the chairman, is it okay if you?
Mr. Urbino?
Thank you, Mr. Chairman. And Senator Scott, I think I understand your question too as being slightly different as well. And I want to add on to what the Secretary said, because that's true. If what you're getting at is the language, which is slightly tweaked, and I'd invite LSO to comment as well, because I think it gets at a little bit of what you're talking about when it says foreign government or foreign non-government person. This was slightly tweaked from the initial language that we had discussed in the working group, which had actually been modeled after Senate File 102 of last year, which was another one of the prohibition of foreign adversaries owning land in Wyoming. And this had been slightly tweaked from that. That had not identified a foreign non-government person, but they're both within the plain language of the statute deemed foreign adversaries under the Code of Federal Regulations. When you go to the Code of Federal Regulations, and I left mine back in my office, I don't have that. It enumerates, yes, a number of countries that are that have foreign governments. It also does identify a person. The person is Nicolas Maduro and the Maduro regime. And I think that's what the actual language, again, I invite LSO to weigh in on this as well. But when we get into foreign non-government person, that was highlighting a specific person in there that was caught in the catchment with the Code of Federal Regulations.
Follow up, Senator Scott? No, was that a no? Okay. All right, with that, did Mr. Pope leave the room? Mr. Pope, are you there?
I am.
I'm moving to the working group now to comment on this bill. Mr. Pope, do you have any comments?
Just a couple, Mr. Chairman, and thank you for the opportunity. Though I see in this that, again, my concentration is on what effects these would have on the businesses that would be dissolved or under scrutiny with this language. And I see in 1716-1420 on page 2 of the bill, Romanet 6, I guess, it has to be in the public interest to dissolve the corporation. As everyone knows, China does business throughout the United States already, but they are listed as an adversarial, foreign adversary by the Secretary of Commerce. And my initial consideration was that this would allow the Secretary of State to dissolve a company that's owned by a perfectly legitimate actor that just happens to form their company within the state of Wyoming. But it all boils down to how that section is interpreted as to whether it is in the public interest. And that's my only comment on this, is that we may be too broad in this, both in that section and in allowing this to happen when it could be happening to a legitimate business interest within the United States. That's really all I have, and I would open that up to questions if anyone has them for me.
Mr. Rubino or Mr. Crossman, in Title 17, is there an appeal process to the district court if you're dissolved, or? Go ahead.
Yeah, yes, Mr. Chairman. I'll give a high level quick overview of what this looks like. So when we get somebody complaining about an entity which has filed a false document with us, we look at it and we attempt to determine whether or not we agree with the statement that it is a false filing with our office. If it is, then we issue a notice of pending administrative dissolution. And that gives them effectively 60 days to respond to us to basically, you could assume it's like a show cause. Show us that what you did is not wrong, or that you have a reason for why it is wrong. At the end of that 60 days, if we don't receive a response, then that administrative dissolution is automatically applied. Well, not automatically, I have to go in there and do it, but it's applied immediately. And at that point, the entity can apply for reinstatement, but it's a judicial process. So they have an appeal to the court to, and that actually just extends out effectively forever, that they can appeal to the court. And at that point, they have to demonstrate to the court in an in rem style action that they didn't do anything wrong. And so there is an appeal after our state. But I'll give you an example of I have at least 2 instances I can demonstrate where in one case there there was a situation where the entity had filed false information with our office, but we determined after discussing it with them that it wasn't in the public interest to dissolve them, and so we did not do it. And in another case, an individual provided us information that would have led me to believe that it was false information, but it turns out that individual was not entirely honest with our office. So we have had situations where these reports have been kicked out for various reasons and preventing the dissolution from happening.
Okay, thank you. Yeah, I asked the appeal question because I'm contemplating what Mr. Pope said about if you've got this perfectly legitimate Chinese company, for some reason, the Secretary of State's office decides that they're on the adversary list, they're an adversary, they dissolve them, they would still have the opportunity to appeal to the district court and prove themselves otherwise, and then reinstate their company if they were perfectly legitimate. Yep, okay. Does that, I don't know, Mr. Pope, if you were familiar with that appeal process, does that ease that concern a little or not?
Yes, Mr. Chairman, that actually does ease that concern a bit. I still believe that in the public interest gives a broad swath of power to define that, and since I can't find a place that it's defined, but that's existing law and it's been there, so I'm not. I don't know that it needs to be changed or that that's what I'm suggesting. It's just that it really does give that broad power that is mitigated somewhat by the appeals process. So I appreciate that explanation from Mr. Crossman. Thank you.
Great. Any other questions for Mr. Pope? No, okay. And we don't have any other working group members. Did they join us after lunch? No. Okay. We'll move into general public comment. Mr. Former Secretary. Mr. Allred.
Thank you, Mr. Chairman. There's just a couple points that I have on this bill. First off, with the memo, and this is something that I've seen all over the place. And unfortunately, the states are the ones that are going to have to fix this. But the supremacy clause doesn't say that the laws of the federal government are supreme. What it says is the Constitution and the laws which are made in pursuance thereof. In the Constitution, we have enumerated powers that we as the people and the states have given to the federal government. In alliance with those are the ones that are supreme. If they're outside the enumerated powers, they aren't supreme to the state. But with this, we're dealing with two things, the supremacy clause and the commerce clause. So one thing people might be concerned looking at this, if we dissolve a company because they're associated with China, does that mean that 99% of everything in Walmart is no longer going to be there? No, it's not, because now we're dealing with the commerce clause, interstate commerce. Whatever comes in, that's the federal government's decide whether they're going to be involved in interstate commerce. But with this bill, one thing that I really do like, the first 4 sections here have the word may. And as you're well aware, may doesn't mean I have to do it. They may dissolve it, they may not, as they've talked about, if it's not in the public interest, if they find other information about it, it's a may. The only two that, and really I wish they would be changed, is in 705 and 904, they say shall. And so those two don't have that wiggle room, don't have that discretion to look at them. They say shall be deemed to be operating without authority. So, and that's existing statute, notwithstanding the amendments that are put in as for the bill, the section D on those. But I would hope that those shalls could be changed to a may. And that would put the rest of this here, that gives discretion there. If, you know, if the corporation is deemed to be an agent of an adversarial government, we still could look at those. The Secretary of State's office could look at them, go through them, and see if it's in the public interest or whatever. But other than that, I like this this bill. I think it is a good one that should be passed out there. Again, it is 100% what I see, as Mr. Rubino has quite eloquently articulated. It is within the boundaries of the state's authority and power. And again, that doesn't mean that they can't go to Nebraska or Colorado and form there. But we can do things that make Wyoming, Wyoming, and hold those out. Thank you. I'll stand for any questions.
Questions for Mr. Allred? All right, thank you, Mr. Allred. Any public comment online? All right, with that, I will close public comment committee. What is your pleasure?
Bill.
It's moved by Senator Landon. Seconded by Representative Harrelson. Was that a motion to pass or just to move it to the next meeting?
I think we already said.
Did we say we're moving all of them to the next meeting?
The reason being these haven't been in the public arena.
That's right.
Yeah. So
Okay.
let's carry them all forward.
Okay. All
Senator
right,
Scott's got his hand up.
Senator Scott,
Okay. Comment.
welcome back,
on
Senator
the,
Barlow.
where we are, and assuming that it is going to next meeting. I very much think it's a good idea to give the Secretary of State, the ability to cooperate with the federal government, to respond to federal requests, to in the scenario that we were given, where the FBI comes and says, you got a problem here, the ability to act. And I thought that the previous comment on the shall and the may is appropriate. We may not want to change those shalls, but we can do it effectively, and so that these provisions are may provisions. I do want to avoid the kind of situation where we can essentially go create our own foreign policy that we don't want to have any Chinese businesses in here. I much rather follow federal guidance, because dealing with a major power like that, and what their citizens can and can't do in this country really is appropriately in the federal sphere, and we should be restricted to cooperating with the feds. So I think this one needs some amendments before we should introduce it.
Hey, Senator Scott, did you want to make any amendments now?
Mr. Chairman, you heard the suggestion I had earlier. I might later on contact the LSO and ask to have one drawn so we have something in front of us. But I think rather than try to make an amendment right now, we need to float the idea out there and see what people can come up with that's creative. I don't have the confidence right on the spot to amend this one.
Okay, I think that is a good plan. If you want to, between now and October, just work with LSO to have your amendment drafted up so we can maybe even get it posted and make it public. Then we can receive comment on it and decide what we want to do with it.
Mr. Chairman,
Co-chairman?
may I have a moment for housekeeping?
Sure.
A little discussing with you. So there apparently are people that want to testify to us in the public hearing process. We always take public comment at these meetings. They want to be able to do it remotely. And it's, I think we should take public comment. I hope it's quick and short, but there are people that didn't sign up as of 5 o'clock yesterday that would like to provide public comment at the end of our meeting today. And I would be in favor
Oh,
of that.
general public comment?
General public comment.
Okay, I'm tracking.
Yeah, so with your, is it okay if we do that?
Yep, we can do a general public comment. That's
Yeah.
fine.
So we will have a general public comment at the end of the day, and let's make arrangements for those people to be on the Zoom to do that. Okay, relaying to folks online that if they will contact the chairman, send one of us an email, that we will give your name to staff so they recognize the request and get you signed up for Zoom. Does that work? Did I do that right? Okay with you, Mr. Co-Chairman?
Yep, that works for me.
And any of you members that are receiving communications from constituents about that, get a hold of them and tell them to send us an email that we'll forward to Ms. Talbert to get them signed up, okay? Does that work? Okay,
You
thank you.
could even, just to make it possibly a step easier, if you're being contacted by constituents, you could text them Katie's email address,
Is that okay?
and then they can just directly go from there.
And that's Katie Talbot, Madam Chief Clerk. Katie.Talbot@wyoledge.gov.
.gov.
Okay. Anyway, we're going to try to accommodate the public comment and appreciate it, Mr. Chairman. Yeah, and we'll get after it.
All right. Senator Boner.
Yeah, and just hopefully not jumping the gun too much before our next meeting, but just want a little bit more explanation about the language that includes or for non-government person. I understand it's owned and controlled by a foreign government, controlled being an important word there, but why are we adding? I think if you have the or foreign non-government person, that could open up to any citizen of these adversarial countries. Just a little bit more information as to why that is. And yeah, I think that's what we should consider as we move forward.
LSO, would you like to comment on why foreign non-government persons made its way into the draft?
Chairman Olson, Senator Boner, that was just to encompass, I think the way that it's in 15 CFR, and I think it's getting at the Maduro regime in Venezuela and the way that that language is drafted there. I think it's pulled directly from the CFR and how they've referenced it to talk about, so we have foreign governments and then foreign non-government persons, and I think that's what that's getting at.
Is that good, Senator Boner?
Yeah, I suppose that makes sense. We'll see if that regime is still around by October, but.
Well, and I think the Secretary of State's office was referencing an individual earlier as well, so it just could be an individual person. Representative Yin?
Mr. Chairman, thanks. The CFR and the statute that we're contemplating here still says that that foreign non-government person has to be determined as a foreign adversary by the Secretary of Commerce. So it doesn't give that authority to the Secretary of State. It's the Secretary of Commerce that determines whether that foreign non-government person is a foreign adversary. I think the question about control is maybe a little bit softer, which is why it's in that staff comment at the bottom of the bill draft. But I actually feel really comfortable about this because of that statutory reference to the CFR, because it doesn't allow for any random citizen of a foreign adversarial government. Unlike some of our other bills where it could have been any random person from any of those countries, whether or not they're involved with the government or not. So I do feel comfortable with that language. I do have two amendments to propose. I'll propose the first one right now, which is I'll move to strike in all of the new language 7.4a and replace it with the new CFR, which is 791.4a. And then I'll add or successor regulation.
It has been moved and seconded.
And
We
so-
already, go ahead.
Yeah, Mr. Chairman, that is the new CFR. It's exactly the same language. They moved it around because of an executive order from 2019, actually, that only got implemented this month. But it is literally the exact same language. And then we add the successor regulation just so if it ever moves again, we'll still capture it.
All right, any discussion? Representative Ottman? In the bill? Well, it's to be in page 3, line 4. And page 4, line 5.
It's everywhere there's new language, Mr. Chairman.
Oh,
The
that
same
appears 3
reference
times,
in-
my
in
bad.
Everywhere there's new language.
4 times, page 5, line 5. Page 6, line 8. I can keep going. Page 7, line 14. Page 8, line 14. I think we got it all that time. Any other discussion? All those in favor signify by saying aye.
Aye.
Any opposed? That amendment has been adopted. Were there any other amendments to this bill? Representative Yin?
Mr. Chairman, so I actually wanted to take a different tact from Senator Scott. And I have language that I thought of. And so my specific concern was CFIUS, right? It was CFIUS specifically. And so I would move to add to the end of new language on each page, except for entities involved in transactions approved by CFIUS. And so that explicitly carves out the one example that I provided.
Okay, is there a second to that? It's been seconded. Discussion?
Mr. Chairman,
Yes, Senator Scott.
Mr. Chairman, in support of this particular change, I think that's consistent with the approach that I'm taking. It doesn't get the full job done, but it sure helps.
All right.
Question.
All those in favor signify by saying aye. Any
Aye.
opposed? That amendment has been adopted. Senator Barlow?
Thank you, Mr. Chairman. So I was interested in former Secretary Allred's comments about the shalls and the latter 2 sections of the bill. I'm not going to propose amendment to them on this date, but I would like some hope that the Secretary of State's office could provide feedback for the next meeting, whether those would be, whether changing from shall to may would alter anything else that they are concerned about. Thank you, Mr. Chairman.
Is that good, Mr. Secretary, Mr. Rubino? Unless you have a comment on it now. Take a look at it and mull it over. Okay,
Mr. Chairman,
Senator Scott. Yes.
following up on that, if there's a reason for those other shalls and we shouldn't change them to may, you can have the same effect by adding a phrase in the new language, if in the judgment of the Secretary of State it's needed, or something like that, so that it's clear that he has discretion in just this section. If there's some other reason, the other section should be shalls.
All right, yeah, we'll hear at our next meeting from the Secretary of State's office regarding the 2 shalls in 705 and 904. Any other amendments? All right. All those in favor of moving the bill forward to the next meeting signify by saying aye. Any opposed? All right. It's moving on forward. Last bill from the working group is 25 LSO 117, registered agents production of records. Ms. Adams?
Mr. Chairman, members of the committee, Katie Adams, LSO. This is 25 LSO 117, working draft 0.4, registered agents production of records. This bill draft generally requires registered agents to provide records to government entities and bona fide law enforcement agencies as specified. So for ease of reference, starting on page 2, I've included the entirety of 1728-108 for reference because I think it provides some good context for the additions that are being made. So I'm going to go ahead and walk through those just so you have that context. So under subsection A, all records maintained pursuant to 1728-107 are subject to periodic, special, or other examination by the Secretary of State or his representatives as deemed necessary or appropriate in investigations. Under subsection B, the Secretary of State may compel production of records required to be maintained pursuant to that statute in accordance with the provisions of the Wyoming Administrative Procedure Act. Under subsection C, the Secretary of State is required to hold any records so obtained confidential, except for information that's already on file with the Secretary of State as part of a public document and information required to be in the annual report. The Secretary of State may release any confidential information only pursuant to a court-ordered subpoena or to a bona fide law enforcement agency for use in a criminal investigation. Subsection D provides that failure to produce or denial of access to records maintained pursuant to 1728-107 to the Secretary of State on demand or failure to answer a validly issued and enforceable subpoena shall be punishable as provided in 1728-109. And then subsection E provides that a business entity that provides false records required to be maintained pursuant to that section shall be punished by a fine not exceeding $1,000 or by imprisonment not exceeding 6 months or both. And so this bill draft creates a new subsection F, which provides that a registered agent shall provide records maintained pursuant to 1728-107 upon request by a government entity or a bona fide law enforcement agency, and no subpoena shall be required to obtain records pursuant to this subsection. And then moving on to page 4, the new subsection G that's created provides 2 definitions. The first is of a bona fide law enforcement agency, which would mean a lawfully established federal, state, or local public agency that is responsible for the prevention and detection of crime and the enforcement of penal, traffic, regulatory, or criminal laws. And then paragraph 2, government entity would mean an agency, department, board, commission, authority, institution, or instrumentality of the state and any county, municipality, or other political subdivision of the state. The staff comment just identifies those records that are maintained pursuant to 1728-107 by a registered agent. And then there's a staff comment about the penalty, and the committee may wish to consider whether to specify a penalty for failure to provide records to a government entity or bona fide law enforcement agency. For example, 1728-109, which authorizes the Secretary of State to impose a civil penalty not to exceed $500 for specified violations, including willful violation or willful failure to comply with any provision that's set forth there. And then there's a suggestion for how 1728-108D could be amended if the committee wanted to include a penalty. And then on the bottom of page 5, there's an explanation of where those definitions came from. And then moving on to page 6, there's a question about the confidentiality provisions and how those would work. So the committee may wish to consider what effect, if any, the requirement to disclose information to government entities and bona fide law enforcement agencies upon request may have on the confidentiality requirements that are currently applicable to the Secretary of State, and whether to further amend 1728-108. So there could be a tension, or I don't know, there could be a requirement to have the Secretary of State keep the documents confidential, but then if they're released to a bona fide law enforcement agency or government entity, and they become part of that government entity or their public records, you may sort of be undermining some of those confidentiality requirements that are currently in statute. And so that's just an area for consideration. And with that, I would stand for any questions.
Questions for Ms. Adams?
Mr. Chairman.
All right, thank you. Oh, yes, Senator Scott.
Mr. Chairman, page 4, line 6, the word traffic. Do you mean traffic as in motor vehicle traffic, or do you mean traffic as in something like human trafficking?
Ms. Adams?
Chairman Olson, Senator Scott, I think that's intended to be traffic as in motor vehicle.
The other would be criminal.
Okay. Any other questions for Ms. Adams or the LSO?
Mr. Chairman,
Co-Chairman Case?
um, I think both staff comments are important. Um, Certainly, we don't want a government entity to release information that the Secretary of State needs to keep confidential. So I think we have to have that one. And the other one I think is good too, with the penalty. So I think staff comments are good. That's good thinking. At the appropriate time, I move to incorporate them.
Okay, we will circle back to that when we get to that place after comment.
Mr. Secretary, yes.
Yeah, Mr. Secretary.
Well, thank you, Mr. Chairman. Of the four bills coming from the working group, this was the one that did not originate from our office. Did want to share a couple thoughts. As a little bit of background, existing statute 17-28-108 allows our office to conduct audits of commercial registered agents to ensure they are keeping complete and accurate records. Utilizing the statute, our office has markedly increased the number of complete in-person audits of commercial registered agents in Wyoming, resulting in a number of active investigations and findings to ensure compliance with Wyoming law. The result from the CRA community has been one of heightened awareness, with current and prospective CRAs inquiring about what information they are required by law to keep for their clients, the business entities they represent. As the law operates today, our office may compel these records and may only release this information pursuant to a court-ordered subpoena or to a bona fide law enforcement agency for use in a criminal investigation. This bill draft essentially allows any government entity, I mean, I think the way I read this goes down to a cemetery district, any special district, to not just law enforcement agencies to compel such records without a subpoena. It is a large policy change. I'm a little surprised, Mr. Meyer, this actually concept he did mention, and then it became a bill draft. I'm a little surprised that he hasn't weighed in more on this one, because I do think this is quite a large policy change to say that any government entity, and even if you cabin that definition a little bit to release this information without any conditions, it's a large policy change. So just wanted to bring that to the committee's attention. I'm sure you saw that in terms of the reading of this, but it's a big policy change. Thank you.
Any questions for the Secretary of State's office? Yes, Representative Farrellson.
Thank you, Mr. Chairman. So as I was looking at this, I did kind of find it interesting on page 4, line 9, where it says government entity means any agency, department, board, commission, authority, institution, or instrumentally of the state, of any county, municipality, or political subdivision of the state. Obviously, I know we use that elsewhere to describe government entity. So I guess maybe asking you or working group, what was the logic behind, I mean, it's kind of, that opened the entire barn door right there. What was the logic behind that? In what situation would we have someone say, we need this information, and down to those extremes in that? I know you mentioned maybe some concern, but like, in what way would we ever see that?
Mr. Chairman.
Mr. Co-Chairman.
Mr. Chairman, thank you very much. Well, we didn't have this at government entity definition, so I completely agree that it's like, there's no qualifiers on this. You know, it has to be a government entity that has a need to know basis. Remember, this all was brought to us by the county assessor in Fremont County, who is trying to determine if corporations that list addresses in Fremont County owe taxes, and trying to do her job and being denied by registered agents any kind of ability to contact the company or even forward information to the company. So that's, you know, it's a matter of having these entities, you know, they owe taxes if they have operations in Wyoming. Assessors have to be able to determine that, and they were frustrated. So assessors are certainly one of the entities. also law enforcement in pursuit, even. So I get it about the cemetery district and stuff. We have to put some language in here that says, about being in pursuit of their legal, obligations or something, but anyway, that's where it came from.
Yeah, I would agree with the co-chairman. The intent was not to cast such a wide net. Assessors and law enforcement, I believe, were the discussions that we had. Representative Harrelson?
Thank you, Mr. Chairman. So in that situation, is the concept of getting a subpoena, is that too troublesome? I mean, I believe that that's obviously a mechanism that we have in our system for the ability to request that. And also at the same place, put a sideboard on. Is that out of the question for our assessors to be able to do? I mean, they can do that.
Well, Representative Harrelson, I think like in the example of law enforcement where they're maybe looking at one potential bad actor, that scenario might make sense that law enforcement would seek a judge, issue a subpoena. I think with the county assessor, that might be an expensive and burdensome process. Because, take the example of Assessor Berg, who brought to us scores of examples. You're going to have to file. I mean, is she going to file a subpoena with a long list? Is she going to have to file multiple subpoenas throughout the year? I think in her scenario, she would be filing multiple subpoenas throughout the year, and that might become a little more burdensome. Also an expense to the county to do that. So, yeah, I think you're right that having you always have the backdrop of the subpoena. But in all scenarios, that might not make the most amount of sense. Yeah, go ahead.
Thank you very much, Mr. Chairman. Hang on. So let me ask this question, and our staff comment talked about the logistics or maybe the legality for you guys as the Secretary of State's office to protect someone's private information and the registered agent's place to protect that information. As we talk about that legality, if we talked about our assessors having kind of a free reign on that information, do we feel like that might be in hedging on that? Because it kind of seems, in my opinion, that it would.
That's absolutely a policy decision, and that is one this committee will have to wrestle with. I mean, consider what is actually being held confidential is an address, a phone number, possibly an email address, and the name of the directors or officers of the company. That's the information that an organization provides to a registered agent, that a registered agent is required to keep. And that's what is not being provided to the Secretary of State's office or to a requesting entity. So I think that would be the policy question of this committee, would be to decide how strict do we want to hold that information in confidence? And you'll have to decide if it's in the public interest to keep that information confidential or if it's not really that big of a deal for you. And the working group really didn't dive deep into that. We just scratched the surface of this before producing the bill.
And Mr. Chairman, I might just tack on a little bit. The Secretary of State can get that information by request. This just says we're letting our government officials have the same access to that information, that limited amount of information. Who owns the company or who the director is, phone number, as the Secretary of State, without a subpoena. So it's not a big bunch of information, but it is what is required by law for the registered agent to keep in the event of a request from the Secretary of State. And we're finding out that these companies have real implications here for our assessors and other government officials, and the anonymity is troublesome. So that's the limit of it. I'm certainly comfortable saying that, to the extent it has to be kept confidential by the requesting entity, that's okay. I don't know exactly how that works sometimes in property records, but there's still got to be deeds out there and things like that, and they're not confidential. So Um, I don't, if the assessor has to keep the phone number or the name of the director confidential, I think I'm okay with that. Um, but anyway,
I think one of the more interesting scenarios that we have to wrestle with here is the scenario where the registered agent is also an attorney. One of the reasons that a person forming a company would hire an attorney to be registered agent as opposed to just hire one of these mom and pop registered agent shops is confidentiality, attorney-client privilege. So that information, when it is provided to the attorney, is attorney-client privileged in addition to privileged under the statute. And I don't know if we would have to have a separate carve out for that, or if the statute itself would be enough to trump the attorney-client privilege, but there's another issue we would wrestle with confidentiality on. And I find that to be a more interesting scenario that we would have to wrestle with than just a mom and pop registered agent disclosing a phone number. Senator Landon.
So I wonder if any thought should be given to tightening that language a little bit. It feels like we're talking about our assessors, our law enforcement agencies. You know, beyond that, I'm kind of with the representative. I'm struggling to, you know, to get on board with just everybody with a government tag having the ability to gather this information. So, you know, we might want to consider that, Mr. Chairman.
and Mr. Chairman, I think I could support that. I think that's probably a good idea. We might want to add county treasurers with the assessors, treasurers, assessors, and law enforcement.
Questions for the Secretary of State's office? More discussion? Go ahead, Senator Landon.
I still see some eyebrows of concern over across the way there. Tightening it up to that extent, does that calm some of the heartburn, or Mr. Secretary, any thoughts on that?
Well, thank you for the question, Senator Landon. I sincerely really do want to tighten up our statutes and get a handle on it. So I am all in on that. I think that confidentiality question, I mean, in terms of providing a different standard for the assessors and treasurers, assuming that amendment passes versus us, you know, I think it should be one of the, you know, it should be the same standard. Either we're all going to be confidential or we're all not. And, but I do think narrowing that a little bit is, you know, I appreciate that conversation. And then, so I think there's two, is that if you're going this direction, if the subpoena has been kind of, that's not the approach the committee wants to take, requiring that, then I think who are they, and narrowing and thinking about who are the appropriate actors. And then two, what is the confidentiality standard in terms of the policy questions? So thank you.
All right, let's move to our working group. Mr. Pope, do you have any comments from the working group on this draft?
I do, and I will appreciate Mr. Chairman, I will appreciate your patience, because I've got a number of things here. First off, as a CPA, and this is where I'm going to be coming from a couple of different hats that I wear, CPA and commercial registered agent here. As a CPA, under both federal rules of practice and state rules of practice, any information that I have, it first carries a confidentiality requirement on my part. That has exceptions, however, and they are interesting exceptions. On the federal side, anything that I use in the preparation of a tax return, which includes, you have to have your name, address, and social security number. In the case of a business, it's a an EIN number, name, address, corporate officers, any of that information, anything that I use is subject to strict confidentiality, except in these two following instances. First, on the criminal side, a summons or subpoena can be presented by a law enforcement agency. Second, on the civil side, I have to receive an actual court order, which a summons or subpoena does not qualify as a court order within those rules. So that presents some interesting situations when I have like a divorce or whatever, and I get a subpoena, and I have to then force counsel to go to court and get an actual court order for me to release the information. Like I said, on the state side, but on the state side, under our rules of practice in Wyoming, it only requires a subpoena to release that information. Now, what we're throwing into the mix is a third standard for any government agency under this definition, which right now, and I appreciate the fact that you will amend this, an instrumentality of the state could include the Wyoming Stable Token Commission asking for information on anybody. It's just, that's way too broad, but it really then adds that third possibility for me. So I have to ask myself how I would comply with this. What would I do if if a county assessor asked me for information that is in my mind protected? Would I require them, since it's most likely a civil matter, to go get a court order and then risk my standing with the Secretary of State's office? By the way, there is one other exception to this, and that is audit by a regulatory agency. So if I'm being audited by the Secretary of State, I can provide the information they're asking for. If I'm being audited by the Wyoming Board of CPAs for any matter, then I can provide the information they're asking for. And I regularly do when I go through my registration process. They ask for information and we do a peer review. So that's the other exception to the confidentiality rules that I have. So I have, as you can imagine, real heartburn over this, because I don't want to put any of my relationships with my businesses at risk of being adversarial to them. So as I look at it now, and under this definition, if a county assessor came to me and asked for information on one of the RA clients, I would have to deny them and then suffer the consequences of that, because of the other requirements I have under both federal and state rules of practice. I'm happy to answer questions on this, and I'm happy to find some sort of middle ground or listen to any possibilities on this, because I also, one of my thoughts was, if we created a system that makes it easier for the county assessors, easier and cheaper for them to either obtain a subpoena or get a de facto court order in order to get this information, I just am conflicted on this terribly.
Senator Landon.
Thank you, Mr. Chairman. So the question then is, if that was your clients that we heard about from one of our assessors, in this case, it was Fremont County, but let's just say that some of those might have been your business clients. Would we then hold you responsible? I mean, that's the dilemma that we face, is that we've had our government officials come to us and say, we've got a problem here. And we've got some of these businesses claiming property that's not even theirs, not paying their taxes. So what is the remedy? Would be my question.
Mr. Chairman?
Mr. Pope, go ahead.
You know, what I'm going to say that I don't know what the remedy on that side is, except that at the very least, a subpoena demonstrates that the entity requesting the information has a legitimate need for the information. The other and one remedy may be that if there is a conflict in that case, or in a case such as that, and by the way, I have one of my firms is in Riverton. I'm not aware that any of my clients were involved in those requests at all, but so Fremont County could at some point have a need for information from me, create a procedure within the Secretary of State's office to route those requests in an audit format. That would, I don't really know of anything else, and maybe the Secretary of State's office has a suggestion to that as well.
Well, let me ask you that question, Mr. Secretary. How would you feel about designing the statute so that the assessor, treasurer, law enforcement, whatever the category is that we decide, has the ability to come to you to ask for the information? And if you determine it is sufficient, just like you would access it under the existing statute.
Well, certainly, Mr. Chairman, we're going to have an interesting ride home discussing that one. But my initial feeling, obviously it's going to probably get carried over pursuant to the direction the committee's taken, which I think is prudent in moving these to the next meeting. But my initial feeling is that I think I'd be okay with that. I think that we'd create a procedure for that. And I think we want the appropriate entity to get this information. I mean, and Assessor Berg, I look forward to talking with her again. I think we've been on the same page here for months and getting these affidavits from her. She's cooperated with us, dissolving these entities. And I think that is really in alignment with the spirit of the code, frankly. I mean, one thing I was going to ask with your indulgence, Mr. Chairman, just one thing I wanted to add to Senator Landon's question that I did not. One thing I would ask is if you don't go that direction and you do narrow the definition, I would ask that our office be in the definition, because my thing is that, yes, we have other statutory references where there are things we can do. But the last thing that I think would be in the spirit of the statute is what's ever in that definition. The assessors can receive more information than the Secretary of State's office. That to me doesn't make sense. And so I think I would ask that we be put in that definition. But I think this approach may be a better way to go.
Well, Mr. Chairman, I think we're going to have to maybe work on that a little bit. I think we hear you, Senator Scott. I've got it right now. Maybe we could tee the bill up to go to the next meeting. We can at least put in the amendments that improve it today, like the two that the staff recognized, and also limit who's gets the information. It's supposed to be exactly the same information that they have to provide the Secretary of State, but I certainly don't have any problem adding the Secretary of State to that same list, as long as it's not circular or redundant in some manner. But we can throw it in there and then have it be the working draft that everybody can react to. So Senator Scott's got his hand up.
Senator Scott.
Mr. Chairman, question for the Secretary of State. and one that I want him to think about, and maybe answer next time. But it looks to me like a lot of the businesses that come to Wyoming, they're small businesses, they're family businesses, and people have many, many very valid reasons for wanting to keep their financial information private. If we pass this bill and it looks like we're making some of the information that is filed with your office wide open to any governmental entity, what risks are we starting to run of driving off many of our incorporations and sending them to other states that are a little more careful in the privacy area? And I guess I really am asking you, and if this bill should go forward, to think about that particular issue and be prepared to answer that question.
Secretary Gray.
Well, thank you, Mr. Chairman. I think, that's always the question, this tension between security and transparency, and then also being business friendly. As I noted at the start, and I did that intentionally, not that I think this is a idea with a lot of merit, and I think I'm supportive of the concept. This was one of the only one of the four that we did not propose. And I wanted to note that I do think it is a big policy change. I do think Mr. Meyer in future, I did talk with him over lunch. I do think he raised concerns, and that probably didn't come in his testimony before lunch just because he it was kind of on the spot. And he does share a lot of these. I don't want to speak for him, and I think it came out in an article that was published yesterday as well. But there's a tension there. And in my opinion of the four bills, the one where it may start to affect the volume of our filings, this is probably the one, in my personal opinion, where we might enter that territory. But I'll turn it over to Mr. Crossman and council if they want to give their personal opinions on it. But that's of the four. But that doesn't mean I'm not supportive of the concept either. I understand there's a tension there, but I think I wanted to note those things.
Mr. Crossman.
Yeah. Mr. Chairman, I think one of the aspects that sets Wyoming apart from many other states is the fact that we do have very strong privacy protections here. And any erosion of that, in my opinion, that I'm not speaking for the office, I'm not speaking for the secretary, I think runs the risk of doing damage to that reputation. And of course, that would manifest itself in a reduction of inflows. So there are other states, a few other states that do have similar privacy protections to our state. They are, I believe, more expensive to file in than our state is. New Hampshire, I think, is maybe roughly double. Don't quote me on that. But those other states that do have these similar privacy protections also, of course, struggle with this. But if we were to erode that, at least in my personal opinion, that would be, as he said, a very big policy change, and one that will likely have many unintended consequences.
Okay. Mr. Chairman. Co-Chairman Case.
Mr. Chairman, let's just look at the big picture here, okay? We're only talking about limited liability companies that use a registered agent. And they do that in Wyoming. We are only talking about companies that claim to have an office of business in Wyoming. And the ones that Assessor Bird brought were many companies. She's the most diligent assessor around the state. It's no doubt happening everywhere. They deliberately tried to deceive the state of Wyoming about their operations. If they hadn't, they wouldn't be on the list. Why do we want these companies to come to Wyoming and lie to us? They would still have all the anonymity if they're a legitimate entity. The trouble is, when they listed their address, they listed an address in Fremont County that the assessor figured out was not really them. They lied. Somebody lied. Now we want the registered agent to tell us more so that we can follow up on this. That's the only companies this applies to. It's not a fishing net. It doesn't automatically make the assessors go after every company. The reason these companies got put on the radar by Assessor Berg is because they listed an address in Fremont County and it was falsified. This is the reputation we want for Wyoming? No. At least pass this bill forward and let's think about this. You know, it's not worth it to have anonymity if people lie to us in their filings and who knows what they're doing. If they lie about that, they'll lie about anything.
And Mr. Co-Chairman, just to reiterate something I said earlier to that point, I think we really have to think about what is really being held confidential is the name of an officer and their address. That's something that a government entity should have access to in order to assess taxes or whatever it may be. I think it's really critical to think about what is being held confidential. How confidential is your name? I mean, honestly, when you're committing a fraud against the state of Wyoming, we're not talking about social security numbers or, you know, information that you might hold more dear and near to you. We're simply talking about a name. So I think that's something to definitely mull over. Secretary?
Yeah, and Mr. Chairman, I think in some ways the initial draft, which is already subject to amendment, may be affecting some of the comments. And so I certainly, with Chairman Case, I mean, I think the intent of this bill is absolutely on the ball. So, I know there's some cleanup amendments here on the side, but I also, if with your indulgence, I mean, Mr. Rubino's kind of been mulling over an approach on what you were talking about, Chairman Olson, to maybe use us as a clearinghouse. And look, I'm not wedded to that if ultimately we go with the original, but I really do think that's in spirit with the way the business code reads right now. And with your indulgence, maybe we move it to the next meeting, but he's sketched it out just here now as we've been talking. Do you want us to do that now or move it to the next, how that could look?
Mr. Chairman?
Co-Chairman Case?
I think that'd be a great idea. Have both approaches presented at the next meeting. I mean, certainly sketch it out what that might look like. Based on the volume that Assessor Berg found, it could be a lot. And so that could be a burden, but I'm not, actually, absolutely, that's a doable way. And we should listen to both of them.
Okay. Mr. Rubino, what have you sketched out?
Thank you, Mr. Chairman. So if you go to page 2 as an example on the bill, page 2 dealing with 1728-108 subsection C beginning on line 24, it really articulates what we have right now, sort of the status that the Secretary had outlined about our office interacting with law enforcement agencies and on response from a court-ordered subpoena. On line 28, the very last word beginning right there, and then on to page 3, the Secretary of State may release any such confidential information only pursuant to court-ordered subpoena. You would delete or, comma, to a bona fide law enforcement agency for use in a criminal investigation. And then you would add language to the effect of, comma, or a county official, being a county treasurer, a county assessor, for purposes of, and then it would be the purposes that they're outlining their need for. And so that would be the interaction with our office. And again, like the Secretary said, I mean, this is only just really articulating this from 30,000 feet because it was brought up as maybe a different avenue that you'd like to go from the direction that the original bill draft was. But I think that would be how you would effectuate it.
Co-Chairman Case?
I think we should do both these and put them on the table and then also allow the assessors and the treasurers to weigh in. But I think it's a great idea. It's a great idea. It's a good way to move us forward. But let's go ahead and get a motion on the bill and fix the things we can fix so that not as many people are alarmed by the content of the bill at this time. And then let's ease into the next meeting on it.
Let me finish out. Is there any public comment on this bill, Mr. Allred? and then we'll jump into that discussion.
Thank you, Mr. Chairman. I know there's a lot of discussion on this, and I think, ultimately, true, we don't want anybody giving false information. And if they do, we already have remedies here. We can throw them in jail. But we also need to look at, right now, Wyoming is one of the top 3 states in the entire country for business filings. We bring a lot of money into this state just because of business filings. And because of that, and the reason for that, why little old Wyoming out in the middle of nowhere can be one of the top 3 is because we protect the corporate veil. There's a lot of reasons for that. Whether it's lawsuits from people who just want to file against a company, but there's a lot of different reasons for protecting that corporate veil, and that's what drives people to Wyoming. Now, I give you an example. I'm just saying that law enforcement or some government agency can just go straight to that registered agent and get whatever information they want. Well, years ago when I was a peace officer down in Utah, we had access to a lot of state records. In order to get that computer access, we had to sign a confidentiality agreement. Every single year, Post decertifies officers for violating that. So to just give carte blanche just because you have a badge or, and I'll tell you right here in Wyoming, we got treasurer's office and clerk's office that leak a lot of confidential information. They shouldn't, but it happens. Now, the one thing about this is for years, the Secretary of State's office has a long history of cooperating with whether it be the FBI or DCI or any of these other agencies to get that information. But letting them be the gatekeeper, that puts a lot on them. But that's appropriate. So if an agency or, a law enforcement authority comes to the Secretary of State and says, hey, we've got this case that we are building on this company, they can provide that information. Now, when it goes to law enforcement or whatever, they can just go, but outside of that, they need to have a court order subpoena. As I look back on my own business, I use a registered agent, and the reason for that is they can serve process on them. It's real hard to serve process on me, but they can serve it to my registered agent who then notifies me. So if an assessor or something has some information or they want to have property records for tax purposes, they can serve it on the registered agent. That's the same as serving it on the entity because they are then required to notice the entity and get those records done. But I do believe by keeping some of these gatekeepers there, that benefits our state. Millions of dollars every year. And it really holds Wyoming up when it comes to corporate business filings. We're held in high regard. Now, do we really want to just throw that away? And I think the Secretary of State's office does a very good job of being gatekeepers on that. And that's part of their charge in that business line there, that they do protect that information, but make it available when it is necessary for a legal case for criminal charges or anything like that. And they're very open to working with these agencies or officers, in those cases. So I really don't see the need for this bill, and I think that it would be detrimental to the state if we pass this. Thank you.
Questions for Mr. Allred? All right, thank you, Mr. Allred. Any other public comment? Public comment online? No public comment. I will close public comment. The first action I guess I would put in front of you committee is to do what we've been discussing. I would like to have an additional bill draft created that uses the Secretary of State's office as the medium for disclosing the information. I think unless LSO has a different way of drafting that, I think Mr. Rubino's example is a good starting point for that.
Second.
It's been moved and seconded for that. Any other discussion on that bill draft? All those in favor signify by saying aye.
Aye.
Any opposed? Okay, so that one's out of the way. Now let's go back to our bill draft that we have.
I would move, I'd make a motion on the bill draft we have.
Yes.
It's moved and seconded. I would propose amendments. The amendments I propose the two that are in the LSO's memo, staff comments. And I would also limit, let's just dispose of that one if that's okay.
Okay, any discussion on that amendment? Staff comments. All those in favor signify by saying aye.
Aye.
Any opposed?
I would,
All right.
I would further move that we limit the access to the information to be the assessor and the treasurer and the law enforcement. I'm happy to add the Secretary of State to that same list if that's appropriate. I think that's duplicated, but that would be the motion. Okay. Ottman, is that a second?
Yep, it's been seconded by Senator Landon.
Mr. Chairman, I think that gets at limiting this and also make sure the Secretary of State's not being end run. It's on equal footing there. So hope we could pass that into the draft.
Okay, discussion, Representative Ottman?
Thank you, Mr. Chairman. To go along with that, if we're going to go in that direction, I would wonder, we're really fortunate that we have a person in office that has a long history of things and also is very diligent in their position, but that's not always the case, and it may not be the case in every county. So if we're going to add people that can get information, could we put in there that they then would have to sign some sort of a confidentiality agreement? So it wouldn't be the whole office, it would just be a certain officer or member or the just the elected person?
Mr. Chairman, I hope we could dispose of the motion on the table, but the staff memo requires that one of the amendments we adopted in the staff memo requires confidential treatment of that information. I don't know that you actually do it by signing an agreement like a business arrangement, but one of the staff concerns that was brought up in their comment was confidentiality. And I think we did say, yes, it should be confidential.
Yeah, I mean, you could, this goes back to, Secretary of State's comments about being treated differently. You could treat them the same in that you could have the same language that the Secretary of State is bound by. When the Secretary of State obtains records or information, the existing statute says that they have to hold it in confidence, and they can only release it pursuant to a subpoena or criminal investigation. You could have that same language apply to the county officers as well.
I think that was the intent with looking at the staff comment and adopting that.
Okay.
I think we did that. I mean, that would be my understanding, is if it's okay. Staff, did you get that understanding? Okay, so I think we already did that.
All right.
So I think that eliminates the need, because the county officer is already going to be bound by that, and the new draft will have that language.
Representative Ottman, is that good? Okay. Representative Harrelson, did you raise your hand?
Thank you, Mr. Chairman. Just real quick. So we asked LSO to build another draft, and that was not an amendment. That was another bill draft, correct?
Correct, yeah.
So we basically are putting two horses into the race and seeing which comes out on the backside.
Exactly.
Beautiful. Just wanted to make sure I was tracking.
Yep.
So maybe we could get a call for the question on the amendment, just proposed to limit it to the county officers and law enforcement and put the Secretary of State in the same language if that's appropriate.
All right, hold on. Senator Scott, do you have a question on the amendment?
Mr. Chairman, yeah, on the amendment, I don't have any objection to us having something drafted we could look at. But I will say that I think we need to be careful about how many people we give access to these records to, because I think the possibility of an accidental leak is somewhat proportional to the number of people that can get access to the records. And so that's something we need to consider if we move this forward to next time.
So, Mr. Chairman,
Senator Case.
and Senator Scott, I think that's exactly what we're trying to do. The only people that can have access are law enforcement, the treasurer, and the assessor, not that broad government list. We're trying to get rid of that broad government list. The Secretary of State has asked that his office be included in that same list. I'm definitely okay with that, and let's do that as well.
Okay.
Question.
All those in favor of the amendment signify by saying aye.
Aye.
Any opposed? That amendment does. That amendment does carry. Any other amendments to 117? Nope. All right, all those in favor signify by saying aye.
Aye.
Any opposed? Okay, that will move forward.
We did it.
We did it. We made it through. We're only an hour behind, folks. The next topic is a light topic. Do you need a 10-minute break? Or you want to keep going? Lock and load.
Guys going to Nebraska.
All right.
You can just allow the members and the staff to exit if they need to.
Okay, if you need water or to use the facilities, you're free to go at any time, but we're going to keep moving on. Trademarks and trade names. We have 25 LSO 16. Mr. Anderson.
Thank you, Mr. Chairman. Josh Anderson, LSO. This bill came out of the April meeting up in Lander. I believe the Secretary of State's office had brought this item as an area that could be addressed by the committee. Essentially, the issue was there was not a way in the office to administratively cancel trademarks or trade names. So the bill, Mr. Chairman, starting on page 2, and you can see in the staff comment there, these provisions are all modeled after the authority of the Secretary of State to administratively dissolve a corporation. So the first one, 41-108, that's related to trademarks and service marks. You can see there, it adds a new paragraph providing that if the Secretary of State finds the cancellation is in the public interest and that the applicant or registrant has provided fraudulent information or has failed to correct false information upon the request of the Secretary of State, they can shall cancel from the register that trademark or service mark. And there is then in the subparagraphs a process they have to follow. In subparagraph A, they would send that notice by certified mail. In subparagraph B, the registrant would have an opportunity to file a response within 60 days. Subparagraph C, if the response does not demonstrate to the satisfaction of the Secretary of State that the grounds for cancellation do not exist, then the Secretary of State shall cancel the registration. And then subparagraph D provides a process for appeal to the courts. And then over to page 4, Mr. Chairman, 42-107 makes that same change applicable to the trade names section of statute. That's essentially the bill, Mr. Chairman. Take any questions.
Questions for LSO? No questions. Thank you, Mr. Anderson. Secretary of State Gray.
Thank you, Mr. Chairman. I'm Chuck Gray, the Wyoming Secretary of State, and obviously to my left is Joe Rubino, our Council or Policy Director. Concerning 25 LSO 16, this bill draft pertains to our office's request for an examination and exploration of ways that our office can better serve the public when instances of fraud, misstatements, or misuse of trade names or trademarks occur. As we outlined during the last Corporations Committee in April, the grounds for dissolution of trade names and trademarks are far more limited than those of other business entities registered with our office, such as corporations and limited liability companies. Unlike corporations or LLCs, holders of trade names and trademarks, with limited exceptions, commonly have to resort to costly and time-consuming litigation in instances of false or fraudulent filings interfering with their holdings. The existing bill draft as written would allow for administrative dissolution in appropriate instances by our office so that holders of trade names and trademarks do not have to expend resources on the judicial process while still allowing for judicial review of administrative dissolutions. I'm going to go ahead and yield to Mr. Crossman on the practical and technical implementation of this bill. It is pretty limited.
Mr. Crossman?
Right. Thank you, Mr. Chairman. Yeah, it's a very limited technical implementation, but it's still non-zero. We estimate it to be about $2,500. We have to go in and have some changes made to the software backend that allows the creation of the administrative dissolution amendment type and a couple of other things. But it's not a ton of stuff, and that's basically it.
In your office, Mr. Secretary, can float that 25.
Yeah, Mr. Chairman, I think we can absorb that one.
Okay.
Yeah.
Any questions for Mr. Crossman or for the Secretary of State? Co-Chairman Case.
I was actually shutting the mic off, but everybody understand this dissolution, the person that asserts that that really is their trademark and may have been dissolved, does have a remedy. It seems reasonable. It's a reasonable balance. This will protect Wyoming companies that feel that their trademark is being infringed upon, and they would be able to show that someone is almost copying their identity or whatever, and that could be useful. So hope we'll support the bill.
Representative Newsom?
So my question is the process when somebody registers a trademark or a trade name, do you do any research as to if there is a similar or the same trademark or trade name registered either within Wyoming or federally?
Mr. Crossman?
Yes, thank you, Mr. Chairman. We do a search in the state of Wyoming. Absolutely. So we look through all of the registrations here in Wyoming. However, while I have done limited amounts of training on my staff as to what the federal registry looks like, we do not typically do detailed trademark searches at the USPTO. That's a relatively in-depth process that is, I believe, considered the practice of law. So we don't do detailed searches at the USPTO. Obviously, if somebody came to us and attempted to register a trademark like Coca-Cola, people wouldn't recognize that and not do it. But there are hundreds of thousands, if not millions, of trademarks at the USPTO that we just would not be able to search.
Representative Newsom?
Thank you, Mr. Chairman. So if I have a trade name and trademark registered federally, and then somebody else comes to register it in the state of Wyoming, then you could dissolve my Wyoming trademark?
Mr. Crossman?
So if I, Mr. Chairman, if I understand the question, the presumption is that there is an existing federal trademark. You have then filed a Wyoming trademark. The federal trademark holder comes to us and says, this is infringing. Would we, under this, be able to dissolve your trademark? The answer is yes, we would start the process administratively. The current process as it exists, absent this law, is the federal trademark holder needs to file a federal lawsuit. In the event that we choose not to, under this new statute, dissolve your trademark, the federal trademark holder would still have to file a federal lawsuit. If we did dissolve your trademark and we are incorrect, you would file a claim against us in administrative court to ask us to reverse it, and then you'd have the state court. And if that fails, you'd go up to federal court. So it actually gives you more capacity to argue against it, but also prevents the from everybody having to go to federal court on day one.
Okay. Any other questions for the Secretary of State's office? Representative Yin.
Mr. Chairman, thank you. Mr. Crossman, so I think my concern about trademarks specifically is that it's specific to the area of business, right? So you could have Apple computers and Apple records, and they both trademark Apple, but one was for music and one was for computers. Now Apple computers controls both, but regardless, the concern I have is, how do you make the adjudication of whether there is an overlap of a good and service for similar trademarks?
Mr. Crossman?
Yes, Mr. Chairman. That is a very good detailed question that will, so when you are doing a trademark conflict analysis, you're looking at, to see, as you said, to see if they're in the same industry, not that you can have two trademarks in the same industry. For instance, that you could have Mr. Plumber for plumbing supplies and Mr. Plumber who is a plumber. Those are both arguably in the same industry, but they're different industry verticals. If you are purchasing plumbing supplies, you're not looking for a plumber. If you're looking for a plumber, you're probably not buying supplies yourself. So even though they're in the same industry, they may be conflicting or not conflicting depending on what the market looks at. So we would need to establish policies and procedures around what we would do. We would make those as permissive as possible, so that we are only looking at things that are very clearly delineated, so that any area where we are unsure would cut in the against cancellation and require them to go to court. But there are instances where people will file something in our office that's turns out to be very clearly an attempt to violate a federal trademark, and we can't do anything about it. I don't want to give specific examples to just disclose whether or not because they're in active litigation, but that would be the situation where we would go after it.
Any other questions for the Secretary of State? All right, thank you. Public comment in the room. Public comment online. Is anyone online wishing to comment on this bill?
Move the bill.
All right, the bill has been moved. And specifically, what are you doing with this bill? Are you moving it to the next meeting, or are you
Well, that's a good point.
a due pass?
Let's do a due pass.
Okay, motion is due pass. And did I have a second? Second by Representative Ottman. Any discussion or amendments on this bill? Representative Newsom.
So I'm going to be a no on this bill because I think the Secretary of State is encroaching on the judicial system. And I think that separation of power needs to stay in place.
Okay, any other discussion on this bill? All right.
So
Go ahead, Co-Chairman Case. I
I definitely get that point. But it's sort of the same purposes as the administrative dissolution of a company with respect to their filings. So, and it does sound like it's taking away some court powers, but actually the court powers are all still there. This gives people a little kind of a easier way to get it handled on the ground, to make someone not have that trademark while it's being ordered out in court. So it's a good point, but honestly, the courts are a really hard place to get things done.
Representative Newsom.
Thank you, Mr. Chairman. Several years ago, we enacted chancery courts for, I believe, just this sort of litigation.
Mr. Chairman,
Senator Case.
we did. We have some chancery court. They're gaining ground and moving. But I would say a trademark lawsuit is a very big thing, probably. This may forego a lot of lawsuits. And actually, if it's dissolved and they really don't want to pursue it, then that sort of speaks to the merits in the first place. The lawsuit is still available.
All right. We'll do a roll call vote on
Mr. Chairman.
LSO 16. Oh,
Mr. Chairman.
Senator Barlow.
Thank you, Mr. Chairman. Just to clarify, this bill also came out of the intervening time between the first meeting and this meeting. So how much time has the public had to see this meeting? That'll determine how I vote in this vote, because I think the last several bills we've had, this was the first time the public has seen it. So just remind me, has the public seen this bill in the intervening time? Same as or not like the others? Thank you. Just a reminder, please.
Well, Mr. Chairman, I think that's a really good point. But I thought we discussed this bill at the last meeting, but I might be wrong.
Secretary Gray.
Yeah, and I think Chairman Case, I mean, I think the distinguishing point on this bill is that this one, there was a bill draft motion in Lander per typically how legislative committees work. This did not get rolled into the working group, and I think the agenda kind of reflects that. This was motioned at the Lander meeting and is now being brought at this meeting. So, you know, I think it's kind of along the lines of how committee bills typically work, where I think Chairman Case, the distinguishment he made on the previous four was that it came out of that working group, which was created in Lander, but none of the bill drafts were specifically contemplated.
Yeah, I would agree with that. Any other discussion? All right, let's do a roll call vote. Oh, that's twice I've tried to roll call this.
So if I can just address one of the comments that this was similar to the dissolution of a business entity. That's not a conflict between two parties. This would be a conflict between two parties, which should be solved in the courts. The dissolution of a business entity is simply a conflict or a fraudulent behavior on the part of a single person and does not involve another party. Thank you.
Representative Yin.
Mr. Chairman, I would just like to ask staff, because I can't see in the minutes on whether we did actually vote on this or how the draft came about, or whether it came from this fraud working group.
Well, it definitely didn't come from the working group because I chaired
Okay.
that.
So then it might
Mr.
have just been a
Anderson?
request.
Yeah, Mr. Chairman, it was a request that came out of the Lander meeting, Mr. Chairman.
Thank you, Mr. Chairman.
All right. Gonna ask for it one more time, but this time I'm serious. Roll call vote.
Mr. Chairman, this is roll call vote for 25 LSO 0016, version 5, trademarks and trade names, administrative cancellation. Senator Barlow.
Aye.
Senator Boner.
Aye.
Senator Landon.
Aye.
Senator Scott.
Aye.
Representative Chadwick. Representative Haroldson.
Aye.
Representative Harshman, excused. Representative Knapp.
Aye.
Representative Newsom. Representative Ottman.
Aye.
Representative Wiley. Representative Yen. Repeat.
Yeah.
Co-chairman Case.
Aye.
Co-chairman Olson.
Aye.
Ten aye. 3 no, 1 excused.
Perfect. And now we're only 20 minutes behind. Executive orders. We have a bill draft 25 LSO 00 or 9 executive orders repository.
Look, the speakers at the console in Cheyenne. He drove to Cheyenne to sit in his dad. Hey, Emily's up.
Welcome Speaker Summers to the corporation's meeting.
Mr. Chairman, Mr. Co-Chairman, thank you. And at what point do you want me to kind of talk about, you know, really why you have executive orders on your plate, kind of from the interim and, you know, the interim work, because I missed your last meeting. So at some point, whenever the chairman would like that, I'd like to give a little explanation of what I've seen with executive orders and why I'm interested in you all discussing that.
Sure. So we'll have LSO introduce LSO 9 to us, as well as the LSO fact sheet. After that, I believe is the bill that you requested to be drafted, LSO 145. So we'll turn it over to you at that time to discuss the bill draft and anything else you want to talk about with executive orders. Miss Adams? Oh. Okay. We're going to switch it up here.
Yes, Mr. Chairman, thank you. Emily Wongan, Legislative Service Office, Legal Division Intern, walking through 25 LSO 0009 version 8. This is Executive Orders Repository, and this bill makes the Secretary of State's office the official repository for executive orders and requires the office to publish them on its website. So currently, the Office of State Parks and Cultural Resources through the State Archives holds these records after 1 year. And there was a similar bill introduced in 2012 that also makes this change and created a definition of an executive order. That is 2012 House Bill 78. So Section 1 amends Wyoming Statute 91302 by adding executive orders to the list of documents of which the Secretary of State's office is the custodian. And also amends 91303 by adding executive orders to the list of documents that the Secretary of State is required to post on its website. So currently, the other two items that are required to be posted are the state constitution and a directory of state departments and selected employees. And so there's a staff comment on page 3 that says the committee may wish to consider whether it would like to define executive order, as that term is not currently defined in Wyoming statutes or the Wyoming Constitution. Additionally, the committee may wish to consider whether it would like to require the Secretary of State to publish, quote, proclamations of the governor proclaiming the effectiveness of the constitutional amendments, corporate revocations, and any other proclamation designated as a permanent record by the governor, end quote, online. Those are just other things that the Secretary of State is already the official repository of. And so as to the fact sheet, as Katie's memo from the last meeting said, the Wyoming Constitution and the legislature has given the governor authority to make orders, proclamations, declarations, and designations. This fact sheet identifies these laws and categorizes them by the type of action, and that is just based on the verb used in the statute. And this is just for the committee to get an idea of what is in law currently. And the second part of the fact sheet on the last page, page 6, just provides a brief survey of other states and how they've defined executive order. This also includes at the top of the table, the 2012 House Bill 78's definition of executive order. And then section 2 is non-codified and requires the Secretary of State to publish the previous executive orders that can be reasonably located, and that was per the committee's request. And section 3 provides an effective date of July 1, 2025. And with that, Mr. Chairman, I'd stand for any questions.
Questions for LSO on this bill draft?
This is great.
Wouldn't you agree? All right. Thank you.
Chairman?
Senator?
Mr. Chairman, I guess I didn't realize that a lot of these proclamations, executive orders, observance by a certain date of each year. That's kind of interesting. Anyway, a great report. Appreciate all your work on that.
All right, thank you. Does the Secretary of State's office have any comments?
Thank you, Mr. Chairman. As 25 LSO 9 interacts with our office and charges our office with custody and preservation of all executive orders issued by the governor through the publishing of executive orders on our official website, I wanted to speak briefly concerning this bill and its implementation. First, I think this bill is good policy and promotes transparency in government. I believe our office is appropriately situated as the custodian and repository for other official acts, the Constitution, rules, etc., to carry out this act. This bill could be implemented by our office. Thank you.
Great. Any questions for the Secretary of State's office? Senator Landon.
Thank you, Mr. Chairman. Mr. Secretary, the staff comment wondered whether or not we would want to require Secretary of State to publish proclamation to the governor proclaiming the effectiveness and but whether or not we should define executive order, do you feel like that is necessary in this bill?
Secretary Gray.
Well, Mr. Chairman, thank you. A definition would be helpful. I think there are some concerns, I'm putting more as a former legislature. I mean, by defining it, maybe because there's always a question about their legal standing, but there are consequences to that. Just kind of putting the hat I used to have back on, but defining it would probably help us in terms of implementing it. But I think we'd be okay either way.
Thank you.
Other questions, committee? All right. Thank you, Mr. Secretary. I will now move to Speaker Summers.
Mr. Chairman, can you hear me okay?
Did you, and actually, let me ask, sorry, I might be getting ahead of myself. Did you want to speak on this bill draft specifically, or do you want to wait until I pull up the second bill draft?
Mr. Chairman, I would rather wait.
Okay, yeah, let's wait. Is there any public comment on this bill draft? 9. No? Is there any public comment online? All right, I'll close public comment. Committee? Been moved by Representative Chadwick. Seconded by Representative Newsom. Any amendments or discussion on this bill?
Passage.
Oh,
Yes.
that was a move do pass. Thank you, Senator Landon.
Just go back to remind me, Mr. Chairman, we had this at our last meeting, right?
I believe we've already seen this one, yeah.
Yeah, so
That's right.
absolutely do pass appropriate.
Mr. Chairman, just to clarify, we discussed the
Bill
potential
draft.
for the bill draft, but we didn't
Yeah.
have the bill draft in front of us.
Yeah.
I thought we did have the bill draft because I thought it was brought to us from like a personal bill or something. Was this one not? Yeah, I mean, maybe I'm just still thinking of Representative Summers's bill.
Mr. Chairman, I'm not sure if there were previous versions of bills that were somehow provided to the committee that were a little bit similar to this. I'm thinking there weren't, but I know those may have been discussed at some point. But this was just a general request, and I think it was a little bit based on after the governor's office spoke about maybe this idea.
That's right. Okay, thank you. Co-chairman Case.
So we do have a motion, right? And
We do.
It's do pass. What about the staff comment about defining executive order? Or do we want to add to that list? I mean, if it doesn't have the words executive order on it, does that go into the registry? It's a proclamation.
I don't know.
I don't either.
I am it could end up having a lot of unintended consequences defining executive order. If we've gone this long in our
Mhm.
history as a state and then issued executive orders, but it not being, written in statute, what that means, I would be a little hesitant that we could craft that in such a way as to not have unintended consequences, but maybe I'm just being overly cautious.
So with that in mind, I think maybe we should pass this forward to the next meeting and get some input on that. And we're too tired to really think this through.
And definitely the governor's office would need to weigh in on that one.
Yeah, I agree. So let's withdraw the do pass or we can do a motion to table it to the next meeting after we get any necessary input.
Representative Chadwick, are you good with just changing your motion to a move to the next meeting? Representative Newsom, you okay with that? Okay, Representative Yin?
Mr. Chairman, just so we have a starting point, I think would be really useful for that executive order
For
definition.
the definition?
Yeah, and so if you look at page 6 of Ms. Wangan's memo, it actually references definitions in different states, but one of the definitions from Wyoming comes from a previous bill from 2012. And I think that's a fine definition for us to insert as a starting point that people can chime in on and
From HB 78?
correct for 2012's
Okay.
HB 78. So I would move to insert that definition into the bill draft.
All right, has been moved and seconded by Senator Landon to include the definition from 2012 HB 78. Any other discussion on that amendment?
Looks like a good start.
Good start. Yes, Representative Ottman?
Can I just have a comment?
Yes.
Okay, first off, a question, Mr. Chairman. In the state of Wyoming, executive orders, can they be rescinded by the next governor?
Sure.
Okay, so if they are, because I realize that we're doing this because of the day in which we live, computers and internet and everything. So should it be that if they are rescinded, that there should be a posting of that as well?
Mr. Chairman,
Co-Chairman Case.
I agree totally that it should be. I view that as kind of another executive order that would go into the list. So you'd have the history of going one way, then going the other. If
Yeah.
I'm wrong, let's catch that for the next meeting. I think we definitely want to have that notation.
Any other discussion on this amendment? All those in favor signify by saying aye.
Aye.
Any opposed? All right, that amendment has been adopted. Any other amendments or discussion on this bill?
Who is that?
All right, all those in favor of moving LSO 9 forward to our next meeting signify by saying aye.
Aye.
Any opposed? That amendment has been adopted.
Let's specifically note that we need to reach out to the governor's office for the next meeting on that one.
Yeah. All right. Last one, LSO 145. Speaker Summers.
Mr. Chairman, can you hear me? I will have a slight pause since I'm using a kind of a satellite internet, but can you hear me okay?
You're a little quiet.
Yeah, I've heard that. I don't really know why. I'll talk a little louder. How's that?
That's better.
So, Mr. Chairman and Mr. Co-Chairman, the reason I'm bringing this idea, really the discussion around executive orders, was really two completely kind of different ideas. One was whether the sage grouse executive order, how it affects development in specifically subdivision development in counties. So there's this issue in my county about what is the real process during the subdivision development. When does the EO come into play? What DQ usually would trigger that with a state action. But the process is not clear to developers on how that should happen, nor really to counties that it exists at all in many forms. And so one of them is just a recognition, I think, or wanting the committee to understand that I think the governor and on the sage grouse executive order really needs to create a process for people that subdivide in order so they clearly understand what the rules of the road were and are. Because I went through this process with a developer to try to figure out what the process was for the states, you know, for the DCT to come into effect and all the pieces of the sage grouse rule. So I think there needs to be work done there, and I think you all can just help support that by talking to the executive branch and frankly by getting some kind of process going. The other was executive orders in general. And so executive orders in general, I have an issue with that the public never really receives the right to talk about them if they go on for a long length of time. And so what this bill does, and it's just an example of what you could do. Obviously you can do anything or nothing. But really what this bill does is says, if you, and I kind of got this idea really from Senator Barlow when we were discussing issues during the session. And really what this does is something very similar to rulemaking. And that is that if you issue an executive order, then after 6 months, you either have to reissue another executive order or you have to go into a process where the public can comment. Now, if you do 2 times, so you basically, if you've gone 1 year with an executive order, then that would automatically trigger a public process where the public can just provide comment on the executive order that's in place. And so the idea behind this really is not for the legislature to get into the governor's business, but what it is designed to do is provide more transparency and more opportunity for the public to provide comment. And whether that would have been the executive order on sage grouse, the executive order on corridors, or other executive orders. If they've gone into place for over a year, perhaps the public should have the right to comment on those. And then the governor could take that comment and do what he wants to it. But it just provides a process to provide public input. And Mr. Chairman, can you still hear me, or am I still breaking up?
You're doing good.
You know, and really the reason is an executive order, particularly the sage grouse order. It can take public property or private property. It can be a takings. You can say to somebody that wants to put in a development of some kind that, no, you can't do that unless you do mitigation or something else. And so I think what I'm trying to get at is I think the public has a right to comment on these executive orders at some point in time. And I kind of did it in 6-month intervals. So that's the genesis of it. And I'll just turn it over to you guys.
Speaker Summers, did you look at other states in terms of a similarity in provision, or why? I'm trying to figure out why you land on 6 months. If you're sold by that, or if, why not 1 year? It's kind of in my mind, why 6 months?
So, Mr. Chairman, the 6 months is not a basis from anything. I just chose that. I thought maybe a year. It doesn't exactly follow the process of rulemaking and the number of days for it, I don't believe. And I just chose 6 months, but then you could re-up it for 6 months. And then if you went beyond the whole year time frame, then you would have to go out to public comment. Public input, I should say.
Okay. Committee, any questions for Speaker Summers? Any questions about the bill draft? Co-Chairman Case?
Well, Mr. Chairman, I do note this bill draft. Everybody knows that it hasn't gone through the LSO process. So I think no matter what we do, we'd be carrying this forward to the next meeting. I do note that there's a definition of executive orders in there that might be better than the definition from the last deal, but we'll fix all that. But I would hope that we would have a decent discussion about this, or if folks are just too tired, we could ask it to be prepared in proper and reviewed by the LSO for the next meeting. Senator Scott's got his hand up, I think.
Senator Scott?
Mr. Chairman, frankly, it was not on the agenda that I got, and I've not seen the draft. I don't have any objection to having a draft prepared for next time, but I would hope we would not seek to amend the bill or work it at this time, because it's difficult to tell exactly what we're dealing.
Senator Scott,
Mr.
yeah,
Chairman?
two things. One, it is on the public agenda, and it was sent out and noticed on the website. But it was, yeah, it came to us later, which is probably why you don't have it, because your packet was probably already in the mail. But I think Senator Case is right. We won't advance the bill as a final bill because of that. And because we have two bills that may have conflicting definitions and other things that we need to work out between the two. Speaker Summers.
Mr. Chairman, thank you. And I totally agree. I just kind of tried to put it in bill form so people could see it, recognizing that it would have to move on. You know, it also has a provision for the Secretary of Estates to be the depository or repository for executive orders. So it kind of rolls in some of what you did in the last bill. And certainly if you all decided to move it forward in any meaningful way, you would probably have to kind of remedy both bills together in the end.
Yeah, I think so. Senator Landon.
Mr. Chairman, I would just suggest, as Co-Chairman Case pointed out, I think everyone is pretty used up by this point, and I like the concept, and I'm glad we're tackling it. I just don't know that we can flesh it out much tonight. I would suggest that we take it forward and work it hard the next time.
Yep. Let's take some public comment and then we'll get to moving it forward. Senator Barlow.
Thank you, Mr. Chairman. So you'll recall, Mr. Chairman, from our Blander meeting, Chief of Staff Perkins was there and outlined some of the current and historical executive orders. And I think having that also part of our next committee meeting would be instructive to the committee. Not all executive orders are the same. Some are very short term, very specific purposes, such as, you know, trucking of propane in the middle of a bad storm, or suspending some regulations for moving of hay during a drought or a wildfire season or something. So some are very specific and very time limited, and some are much longer. And I think what Speaker Summers is talking about is probably the longest ongoing successive executive order in Wyoming history, and that's the sage grouse one. So I think we need to understand the nuances that exist out there and make sure if we're going to move forward with this, which I think there is merit in it, we're cautious about how we approach it. The as this committee probably recalls, and many of you are familiar with, in our rules process through the Administrative Procedures Act, emergency rules can be put into effect for 120 days and then extended for another 120 days. So the 6 months is longer than 120 days, but anyway, so there's some things to work with. And in the conversations that Speaker Summers and I had, that's what we were trying to get to, is just a process so that folks could, if we need to respond to something in an emergency manner, we could, but then you have time to reconsider things and get new information, and the public shouldn't be involved in that, even though this is an executive function, and the executive branch will defend their Article 2 separation of powers. That's fine. That doesn't mean we can't outline some parameters by which it should be carried out. So thank you, Mr. Chairman. But I do think that information from Chief Perkins will be informative as we consider this at the next meeting. Thank you.
Thank you, Senator Barlow. All right. Let's move into public comment. Mr. Allred.
Thank you, Mr. Chairman. Last comments for the day. But when we're talking about executive orders, there's a little bit of concern, some of these items. I think Senator Barlow had some excellent comments on this. But, you know, if you're talking about moving propane or hay or something like that, that's a very short-term deal. But on page 2, line 15, where it says it has the force and effect of law. I have a problem with that. Constitution says only the legislature can create law. Why are you guys giving up your power? You know, executive order is a directive from the governor from the state that manages operation of state government. That's fine. That's his job. But to create law? No way. I think that should be removed. That's my personal thing. And I do like on page 3, line 4, no executive order shall be valid or effective against any person, nor shall it be invoked by the governor for any purpose until it's been filed with the Secretary of State and made available for public inspection. Well, you know, when it comes to executive orders, if they want it to be effective law, whether it be the sage grouse thing that Speaker Summers referred to, or the biggest one that really everybody in this state was against was issues around the so-called pandemic. That affected everybody in this state. If we're going to do something, if the governor's going to issue an order that he wants to have effective law, then it should be presented to the legislature and let those representatives of the people pass it as law. You know, the governor does not have the authority to make law. A short-term thing, as mentioned, that's an executive order. Let's deal with that. But if you want to try to make it an effective law, that's your job, not his. And it needs to be held by you guys jealously. That's the charge as representatives of the people that you're given. And so I don't like that force and effective law. I'd like to see that removed, but that's what I like. Thank you.
Thank you, Mr. Allred. Mr. Rubino, we do have some public comment, general public comment that we are aware is going to occur that may be directed towards the Secretary of State's office. So I don't know if you want to stick around or if the secretary wants to stick around, but just giving you a heads up that there is some public comment that you may want to listen to, if not respond to. Any questions for Mr. Allred? All right. Any online?
Mr. Chairman,
Yeah. Senator Case.
it's a difficult area. I certainly get the legislature makes laws, but we can't come back into session to handle a propane emergency in a timely manner to get propane moving around the state. So having the governor have emergency powers that have to be enforced by law enforcement, Department of Transportation, others in the state is not unreasonable. So it's a fine line. Is that the force of law when he directs that we override the weight restrictions to get propane across bridges in Wyoming to freezing people? Is that the force of law? Well, he's overriding the weight restrictions that the Department of Transportation needs to enforce. It's just an example. And it may allow drivers to work longer. So it's not, that force of law may not be the quite right word I'm looking for, but it has a way of working, bending the laws a bit, so I suppose, so that we can handle an emergency. That seems perfectly appropriate and within the realm of what the executive should be able to do with, and I leave it at that. It's a fine line.
All right. Any other public comment online? No, closing public comment. Committee members. What is your pleasure?
Let's move this to the next,
Next meeting?
yeah.
Move LSO 145 to our next meeting. It's moved and so eager to second this one. Seconded by Senator Landon. We're getting tired.
Notice that the Senate is helping the Speaker of the House. Let's just note that right here. Who we're going to welcome as a colleague, perhaps.
You know that, we had a second online.
There was a second online.
There's another senator.
There's a lot of eager senators to second this bill draft. Okay.
The only ones wanting a movement here.
That's unusual.
It's unusual that we're awake.
All right, any discussion? All those in favor signify by saying aye.
Aye.
Any opposed? All right, and that one does move forward.
And the idea, I think, would be that we team up together and handle them at the same time.
Someone said, Mr. Chairman. Oh, well, I had Mr. Kennedy down for general public comment, so maybe we'll bring him in first anyway. No, just Mr. Kennedy first. Welcome, Mr. Kennedy. This is our section of general public comment, so you're welcome to comment on anything that we've covered over the last 2 days. Or
Thank you,
anything else you'd like for us to hear.
Thank you, Mr. Chairman, and this is unrelated to any of the topics that you covered yesterday or today. Keith Kennedy on behalf of the Wyoming Association of Irrigation Districts, and we would like to ask for a draft bill to increase the bid requirement threshold in Wyoming statute 417412 and 417813. 412 is currently set at $7,500 and 813 is set at $1,000. We believe that the level set for municipalities in 15.1.113 of $75,000 is appropriate for these sections of irrigation district statute. Prior to 1999, both 417412 and 15.1.113 were both set at $7,500. The irrigation district statute has not been changed since that time, while the municipality statute has been increased at least 3 times. 417813 has not been changed since 1957. I would also add that I think it would be reasonable to have some of those additional requirements, for example, that are in the municipality statute for a requirement for automobiles and trucks to always be let to bid. I would also note for the committee that these districts are created by and must report to a district court as detailed by state statute. All of them are audited each year and are also responsible to the members of the district, primarily farmers and ranchers who irrigate. And with that, I would welcome your questions. And if the committee doesn't feel that this is within their mandate from management council, that we'd like to have someone bring this as an individual bill. And with that, I would welcome your questions and wish you all Godspeed on the way home.
Thank you, Mr. Kennedy, for bringing that forward to us. I do think that it is topic wise, you're in the right committee. You're definitely in the right committee, and it is something that we would typically deal with. I question whether it falls within our management council directives that we have for this interim. Also, even if it did fall within the directives, I'm a little hesitant to say now would be a good time to take on that bill draft, because typically we're reserving the last meeting for final passage of legislation. Usually we're not drafting midway through. We try to get those drafts in through our first session, just to have proper notice, proper time. So at least that's kind of my thoughts on it. I don't know, Senator Case, how you feel about it.
Well, Mr. Chairman, I'd kind of like to help them out, to be honest. They're pretty simple bills. It's certainly an oversight that we haven't raised their limits over all these years. Management council never comes back and checks, actually. That's true.
And we only have 50 bills.
Double check us.
Well, and we could pawn them off as individual bills, but if we just had them drafted and posted, pick a number as a placeholder, Nick be blank XXX. And then peel them off as individual bills is a fine way to go.
In other words, Co-Chairman Case is less of a curmudgeon than I am.
That's because I'm been around curmudgeons all my life, all my legislative career.
All right. Anybody have any objection to having those bill drafts created? We'll take a look at them. We'll decide whether it's a lift we want to take at our next meeting. Otherwise, they'll exist for individual sponsors.
Yeah, and Mr. Chairman, irrigation districts are an interesting thing. They're actually under the jurisdiction of the court. They go through the county commissioners, for example. They're a little bit out of public scrutiny in some sense. I know that the members and themselves pay very close attention to this. I'm not saying that, but a municipality, of course, has their own public requirements. So I'm not quite ready to go to 75,000 probably, but certainly we could make some big improvements that help them out.
Mr. Chairman.
That's
Mr.
Josh
Anderson.
Anderson. He runs
Just for clarity, staff caught the two statutes that he wanted to increase the dollar amount. I thought there was maybe another piece to the request that we didn't catch. So just wanted to clarify that, Mr. Chairman.
Mr. Kennedy, did you catch that question?
Sure. Mr. Chairman, I don't believe that there are any others, and we actually caught the 41-7, 813 somewhat by accident because the districts for many years have just relied on the earlier 41-7, 412. So apparently everyone has been missing the one that hasn't been changed since 1957.
All right. About time to update it, I suppose. It's only been 70 years. Okay. All right. So Mr. Kennedy, if you would, you can join us by Zoom next time or in person, whatever fits your schedule. But if you wouldn't mind joining us so we can talk about those bill drafts more in depth, we'd appreciate it.
Certainly. Thank you, Mr. Chairman.
All right. Thank you.
Just as a placeholder conversation piece, why don't we start them out at $20,000 and eliminate the requirement for the. Is 20,000 okay?
20,000 is okay with me.
And that's just a placeholder.
All right. We have additional public comment. 3 individuals. Okay, go ahead and let them in.
Chairman.
Yes, Senator Barlow.
So that was just unanimous consent that we're going to advance these bills, or do you want to vote?
Oh, sorry, I looked around the room and I had a bunch of head nods. But we can vote just to make it formal on the record. All those in favor of the bill drafts going forward to our next meeting, signify by saying aye. Aye. Any opposed? All right, thank you. Thank you, Senator Barlow. Welcome, former Representative Duncan and Representative Larson. Ms. Duncan? Go ahead.
Mr. Chairman, can you hear me? Because I'm using headphones, so I don't know if you can hear me or not.
We can hear you loud and clear.
Okay, sorry, it's really loud here. I'm in a conference center. So, actually, I believe, I don't want to skip protocol and have Mr. Chairman, jump ahead of a sitting legislator. So I'm okay to wait. If, you want to have him go first, it's up to you.
That was a very creative way of punting. Representative
No,
Larson,
no.
would you like to address, Representative Larson, would you like to address the committee?
Yes, thank you, Mr. Chairman. And I actually am not speaking on behalf of my legislative capacity today. I'm speaking on behalf of an individual running for House District 17. And most of you have heard in the news lately that there have been mailers circling around our state that have inaccurate claims about legislators making votes on things that we never voted on. One of those accusations was that I voted to take Trump off of the ballot, which we never took a vote on that. So I just think that we're going to be seeing a lot more of this if we don't address it as a state. A lot more lies coming out in political campaigns, and maybe not even direct lies, but just misleading voters. And it seems interesting to me that the same people who tout election integrity are the ones that are lying about certain votes. So and therefore taking away the integrity from the process.
Thank you, Representative Larson. Any questions for Representative Larson, committee? Co-Chairman Case?
Well, Mr. Chairman, I definitely am aware of what happened, and I find it appalling. I saw the same mailer in a local race in my within my Senate district, one of the House districts. The ability of this committee to do anything about that in a timely manner for this election is absolutely zero. So, but it is important to register the concerns and the concerns of people all around Wyoming, because we all want elections to be fair and honest. And so I suspect the big picture is that this committee will debrief after the election, and we'll go into the next interim with the idea of looking at what happened in this election and to kind of drill down on that. Free speech is a very, very powerful constitutional right, and to require to infringe on that is a very big deal. I think with your own lawsuit, I think that's appropriate. I'm not sure how that'll be handled by the courts, but how the courts handle that will probably play into the thinking of our interim topics, I would imagine. I wish I had a better answer, and I wish I could push a button and make it stop. It's heartbreaking to me, having been in a lot of elections in Wyoming, to see this happening. So thank you for coming, and thank you.
Thank you, Representative Larson, for your comments. Senator Scott, yes.
Mr. Chairman, just very briefly, second everything Senator Case just said. And I would add one word of encouragement from my experience over the years, dating way back to well before I was a legislator. The voters have done a pretty good job in the past of appropriately disposing of these issues and the people that are abusing them. And I suspect when the election's all done, we'll find the voters did a pretty effective job on this issue again.
Thank you, Senator Scott.
Mr. Chairman.
Who is that? Representative Yin?
Mr. Chairman, so I have an associated concern. So I did read reporting on Cowboy State Daily that stated that a Republican county party gave money to the PAC that put out the flyers that Representative Larson is complaining about. And so I do have a concern on whether one of those groups is breaking the law and whether that's being investigated in any way, because there is a statute, and that was in the reporting, that disallows a party from participating in choosing one candidate over another within that party primary.
Mr. Chairman?
Yeah.
Mr. Chairman, I'm aware of that. I'm not going to ascertain to the facts, but there is a specific statute that in Wyoming that requires that support not be given financially by political parties. It's a little different there might be a PAC, for example, that calls themselves the so-and-so party political action committee, and it's not actually the party, that they're not governed by the same rules. But in this case, I'm informed that it was a specific party that gave the money to support a slate of candidates in the primary election. My understanding of the facts at this point in time is that the party believes that they did not violate the law because it was sort of given to PAC supporting a slate rather than any individual candidate over another. I don't think that'll hold up in court. I'm aware that there are some plans to challenge it legally. So where that will turn out, I'm not sure, but I did receive some calls on this, and that's as much as I know to everybody. But there is a specific statute, and it doesn't seem to make any sense or protection in that statute to me for someone to say we're getting involved in the primary, but we're doing it as a party through a PAC that gets to greenwash it somehow or not. It doesn't seem to hold muster with me. Again, I hope that one is successful. I think it's abhorrent, and it changes it will actually backfire in a very big way. So thank you, Representative Yen, for bringing that up. It's sort of dirty Republican politics in a way, and it's good to have a good friend in the other party that will bring it up, and appreciate it very much.
Mr. Chairman.
Well, in Co-Chairman Case, to your point, the statute is 22-25-104, and it actually says no political party funds shall be expended directly or indirectly in the aid of the nomination of one person as against another person in the same political party. So I think the legal argument could simply be made that it was indirectly given to through the PAC. Yeah. So I do think it's definitely going to be an interesting legal question to wrestle with.
Mr. Chairman.
Representative Yin.
Given that Mr. Rubino is still in the audience, I was wondering if I could ask him about both the press release that got released today or yesterday about the Secretary of State is investigating a PAC on whether it is performing illegal behavior. And so whether they would also investigate this PAC on whether it's performing illegal behavior.
Mr. Rubino. I take it you heard Representative Yin's question, or do you need him to repeat it?
No, I heard it, Mr. Chairman.
Mr. Rubino, go ahead.
Thank you, Mr. Chairman. Yeah, we take all election complaints very seriously, all allegations of any alleged violation of the election code very seriously. And, we'll review those when we receive them.
Representative Yin.
So, Mr. Chairman, is Mr. Rubino saying that you need an actual complaint for you to conduct an investigation, or are you going to conduct an investigation into that PAC based on that reporting?
Mr. Rubino.
Mr. Chairman, Representative Yin, are you referring to Act Blue?
So, Mr. Chairman, if I may.
Representative Yin.
So, Mr. Chairman, Mr. Rubino, so there is a press release saying that the Secretary of State's office is investigating the Act Blue PAC. And so my concern is that there is also a PAC that, based on the reporting, looks like it is violating the law. Is this something that the Secretary's office will investigate, or does a complaint need to be filed to make that happen?
Well,
Secretary of
yeah,
State
thank you,
Gray.
Mr. Chairman, Representative Yin, certainly invite you to submit a complaint if you'd wish to do that. Act Blue, there are wide reports of Act Blue filing straw donations. And we take that very seriously, as I hope you do, that straw donations are very problematic and illegal behavior. So we're investigating Act Blue. We take all complaints seriously. We have not yet had that party do their YCFAS filing yet. So how do we know that the transaction actually occurred? There's been no filing by the party yet because that deadline is not passed. And there's been no filing by the PAC. So that deadline will pass at some point. And I understand ideologically where you're at on this, but we have to apply Title 22 in the law equally. And we don't yet have evidence whether that transaction actually occurred.
Representative Yin.
Mr. Chairman, thank you. Mr. Secretary, I appreciate you sitting down. The reporting literally quotes Sherry Davis, the Crook County State Committee woman, that they consulted with an attorney before making the donation. So unless the reporting is incorrect, they are literally saying that the Crook County GOP made that donation, and they say it's legal. So if you want to wait until filing, I mean, I think that is your prerogative. But as you both know, that the election is coming up very soon, so I think it is appropriate to investigate something like that.
Secretary Gray.
Well, Mr. Chairman, we'll certainly investigate everything that comes to our attention. The legislature has set those deadlines. Obviously, that quote pertains to the check being written. It does need to be cashed. There's two sides on a check, right? And so we'll wait for those filings. In the meantime, I think a complaint, we invite everybody to file complaints if there is an issue. And, you know, in terms of Title 22, I think that complaint could identify any possible violation or alleged violation.
Mr. Secretary.
Yes,
Chairman?
Senator Case.
Would you mind taking a second and explaining to the people that are listening to this and some online people that are concerned about this election, what the complaint process would be, say in the case of Crook County's donation?
Secretary
It
Gray.
was reported in the papers, just reported.
Well,
Secretary Gray.
thank you, Mr. Chairman. So on our website, if you go on the home tab, it's sos.yo.gov. You go on the elections tab, and then you go on elections home, and you scroll down. On the right-hand side, there's a tab that says administration. Right under that, there's a link that says election complaint form. So you click on that, print it out, or whatever means you want to fill it out. And there's an email to send it to. And that's the complaint process. And so it's right there on the website. As you can tell, I've gotten pretty used to directing people to it. And certainly we take all complaints very seriously. But, you know, I was in a conference call out there, but also in and out listening. And you know, I want to underscore a little bit what Senator Case said. Speech is very important. And all of the folks that are talking about mailers and the content in them, I've yet to hear a Title 22 issue. And so I'd invite individuals, if there's a Title 22 issue, then that's something that our office has jurisdiction over. But, you know, these opinions are in the eye of the beholder, okay? And in my oath and in what I have jurisdiction over, it's what's in Title 22. And I invite anyone that's has concern on the content to identify something that is a Title 22 issue. There are remedies for these. And look, I have a lot of experience on this. You know, running for office, I always told everybody, wait till 2 weeks before the election, because they're gonna, and literally 2 weeks before the election, an individual filed a complaint with a federal entity alleging that I had committed crimes. And, you know, unlike some of the other mailers that the media is quote unquote debunking, that one, the media was all in on just repeating the claims, and it turned out to be totally false. And I just given that as an example. Okay. It's just one example. So we all have experience with these things, but there is a remedy in the civil courts. And we've got a lot of attorneys here. I think certainly that'll be an interesting process. But in terms of Title 22, that's what I have jurisdiction over. That's what our state has jurisdiction over. And, you know, the folks talking about these mailers, I invite them to identify what the Title 22 issue is. And then if there is one identified, then file it with our office. But free speech is a very important part of our republic, a very important part of our republic.
Mr. Chairman.
Co-chairman Case.
And Mr. Secretary, you and I are on the same page about free speech, and but the Title 22 violation, I think is right up your alley, and of course the prohibition on political parties either directly or indirectly supporting candidates in the primary election is right there in Title 22. So I think that will be in your bailiwick, and I suppose you'll first see it as a complaint.
Thank you, Mr. Chairman. And just to clarify, I was talking about the first comment.
I know you were, sir.
Thank
The
you.
free speech in the
Yes.
mailer, and we're both on the same page.
Yep.
Yeah, when you get a mailer that alleges something, that's a little bit harder to get your handle around.
Senator Boner.
Thank you, Mr. Chairman. Just a little bit more information on, I think, Senator Case's question. So once you receive the complaint, what are some of the possible outcomes? Obviously, you're not a law enforcement agency, you're not a court. What are some of the potential outcomes once you conduct your investigation, just so everybody understands I should say, sets our expectations as to what you do and don't do.
Thank you.
Secretary Gray.
And thank you for that question, Senator Boner. I really appreciate it, because I think the media, I don't know if I don't want to get in their heads, but I don't think the reporting on this has been entirely accurate. The Title 22 is very clear that we have one authority over these, which is to forward them to the appropriate law enforcement official, which in some instances is the Attorney General, and in some instances is the county attorney or DA. And that's laid out in state law. I don't have any prosecutorial authority. It's just forwarding it to law enforcement if I deem that they have merit. And that's paraphrasing the statute.
So, Mr. Chairman.
Representative Yin.
Mr. Chairman, thank you, Secretary. So if you're waiting on both the complaint and the filing for the Crook County GOP and the Freedom PAC, what spurred the investigation on Act Blue? Was there a complaint, and was there a specific Title 22 violation that was in that complaint?
Secretary Gray.
Mr. Chairman, there was widespread reporting on it and anecdotal information received by our office. This is the first that I've come to receive any information on this article. I didn't see the article. And as far as I'm concerned, the check hasn't cleared, but we've received information that Wyomingites have been impersonated on Act Blue anecdotally, and that to me is reaches the status of a complaint. But in this other situation, you have to have a check that clears, right? A check, just writing out a check doesn't execute the check, correct?
Mr. Secretary, how do you know the check hasn't cleared?
We don't.
Oh, you don't. Okay. I thought you said, as far as I'm concerned, the check hasn't cleared.
Yeah, we don't know.
Because you just don't know.
We don't know.
I got you. Okay.
So
Representative Yin.
Mr. Chairman, thank you. Secretary, so in the widespread reporting, there were actual Wyomingites that were reported as being straw donations. You have that reporting that you can share with the committee that initiated that investigation, as opposed to this reporting that has not yet initiated an investigation, and that you're unwilling to initiate until a complaint comes in after a filing.
Mr. Chairman, you're also really grasping at straws, because an investigation is different from forwarding a complaint. We didn't forward a complaint on Act Blue yet. We began an investigation because of the information that we've received. So that's very different. Do you understand that difference? Forwarding a complaint versus beginning an investigation?
I think we should be really careful about going through the chair.
Right.
Thank you.
Yeah, thank you,
Mr.
Mr.
Secretary.
Chairman. There's a difference between investigating and forwarding a complaint. And so there's a huge difference there.
So
Representative Yin.
Mr. Chairman, thank you. So Secretary Gray, so if you don't need a complaint to start an investigation, when the filing happens and it appears that the party has given straight to the Freedom Pack, if that happens in their filing, would you open investigation?
Secretary Gray.
Mr. Chairman, I got to evaluate the facts on that. And, I think, that's an evaluation of the facts. I have an oath and I'm going to follow that Title 22 and we have received information on straw donations, which is very serious. We had not received any formal communications regarding this other allegation. We have received none. And so I think there's a huge difference there.
Representative Haroldson.
Thank you, Mr. Chairman. Sorry, we've spent a half an hour on speculation at this point. And I'm just asking the question, is this really our place? As a committee for something not on the agenda, something that really there's no action we can take. I'm just questioning.
Representative Haroldson, we're in general public comment. So under this section, it really is any comment that the public wants to bring in front of us.
Okay, I understand that. We've just been a half hour past the public comment now.
Well, and Mr. Chairman, I will say, I think a lawmaker using this as a forum to discuss a political issue, I'm uncomfortable with. I take very seriously this investigatory authority, and this is a taxpayer-funded meeting, and I think we will evaluate these and take them as they come.
Senator Landon.
Mr. Chairman, as a past chairman of this committee, corporations, elections, and political subdivisions, I would just say, in a general sense, Mr. Secretary, I've had so many constituents come to me this year on the question of elections. A, is there any investigation or oversight as to who's reporting what? B, what are we going to do about misleading and outright lies in mailers? I'm not saying we can do anything about them, but I respectfully disagree with the representative from Wheatland. This is our bailiwick. This is what we're supposed to be doing. And it's a very real concern out there. I wonder if you share the concern about what's going on in our Wyoming politics now. It just feels like we're sliding down the slope. And when you have mailers like that go out, I've seen them in my district. I'm not running this time, but I see the mailers and I just think, wow, we're getting to a pretty dangerous level here. Do you share that concern? I'm just curious. Is it something that we should be concerned with, or does free speech mean you can say anything at any time in any way against anyone, because by the time they take it to court, it's too late anyway, right? That's my concern. And so I don't really have any answers to my constituents. Like, well, I guess we just take it. Just take it. I'm not sure we can do anything about it. I'm just wondering if you as a Secretary of State or other secretaries of state, is this something we can do something about?
Secretary Gray.
Well, thank you, Mr. Chairman. That's a question I really do appreciate. And, being able to serve in this role it's an honor of a lifetime. Every day I enter my office and I get to see the room where the Constitution was signed out of my window. And I take a lot of people through the Capitol and through the House chamber. As you know, I used to be a House member. And on the sides there's that composite from the 1910s, whatever year it was, where there's a rip in it because literally the members refused to be in the same composite together, or at least that's the legend. that's been told to us, and Democrats are labeled and Republicans are labeled. Been reading a lot about Civil War period and early American history recently. Political life has always, there's always been a vibrant back and forth. And the idea the media tries to create that this is new, I just highly disagree with it. I mean, there was maybe a period from 1930 to 1960, maybe, especially in the 50s, but there has always been a vibrant discussion because this is our kids' and grandkids' future. The stakes are incredibly high. And so there's always been a back and forth, and our country has been built around the concept of speech and vibrant debate. And I believe in that. There's nothing in Title 22. I invite anybody to point out something in Title 22 that has to do with some of the allegations of the first commenter. And but I'll note too, Senator Landon, it always seems when it's one side getting attacked, it's always that side that has the issue. When I was getting, when I don't want to make it but when somebody else gets attacked on something false, if you're not in their bucket, the other bucket doesn't say anything about it. And so I think the way I think about it is on the personal level, beyond executing Title 22 in my oath, is that we need to work on honesty across the board, on our rhetoric and on what we say, and need to be, no matter which side it is, equal. If something inaccurate is said on the other side, point it out, just like if something's inaccurate on your box that you're in, or your friend, or your political, because, let's face it, there are two very different boxes within the Republican Party right now. So, so I guess I would just say that we execute Title 22. I take my oath very seriously. I don't think in terms of the first commenter and the allegations in relation to the substantive mailers, I haven't seen anything come across my desk with somebody saying it violates Title 22. So, and I think there is a venue for their concerns. Leave it at that.
Mr. Chairman,
Senator
thank you.
Landon.
Thank you, Secretary. I do appreciate it. And I appreciate the opportunity for a little bit of dialogue. It's an important issue. And I get the Title 22 stuff. I think it's beyond that. I think it's a bigger thing going on. And it is concerning to a lot of people. And you're right. It's not, I don't mean to come off as one-sided. It certainly wasn't intended that way. There's just a lot of dishonesty and outright distortion of the facts going on. And it just makes me wonder if this committee or anyone can do much about that. So thank you.
Mr. Chairman.
Chairman Case.
Do you think we could maybe get the rest of the public comments online? And then, we could have a brief discussion and then wrap up.
We
this
could be here
meeting.
all night.
Well, there are members of the public that are online waiting to testify on
Okay.
these issues. And
Ms. Duncan, you had punted. Now you're up. Do you have some general public comment for us?
Yes, thank you. Can you hear me?
We can.
Okay. I don't want to reiterate some of the things. One of the things is freedom of speech is great, but there are consequences for your freedom. The government can infringe on you, but general people next to each other, publicly, whatever, you have libel, you have all these other issues. The problem I have is that we have some sitting legislators being involved in some of this. So, at a PAC level, that's the part I'm having problems with, of flat out lying, misleading and manipulating the public on bills. And we can talk about all the other companies that are doing them too. For example, AFP, they're sending out, hurtful flyers too. But the difference is they actually list the bill for the public to be able to go and investigate for themselves. These others are not. So they literally lied in the one that Representative Larson is talking about. I went through, I searched, I found the bills, I found the votes, and it was really far reaching for them to even say everything that they said. So I have a problem with that. There needs to be some accountability. We used to, and I know we can't legislate behavior, moral behavior, but we used to not be able to attack our own members. You can call me whatever you want to call me. Personally, you don't like me. I don't care. But when you lie about things in print, there are consequences. So that's my issue. You know, I had one of the horrible experience with these. And I sat there, and when other people attacked my opponent, I came out publicly and said, this isn't allowed. You know, I didn't condone this. So they're just, I don't know if there's an ethics thing going on or what, but I do think that when you flat out lie, that's a difference than just being negative. That's all.
Well,
Mr. Secretary, looks like you want to comment.
Yeah, thank you, Representative. Thank you, Mr. Chairman. Ms. Duncan, former Representative Duncan, you know, that is in the eye of the beholder. There are many people who disagree with you. And I've talked to both sides of this issue. There are many people that believe that those mailers are an accurate reflection in their opinions. And there's a venue for this to be debated. And I think many people may very well be called to the witness stand and give their opinions on every one of these mailers. And that's the venue for it. But Title 22 applies to everybody equally, no less, no more, including legislators. And, you know, I would push back with you a little bit, Representative Duncan. A legislator has the right to speech just like any other individual, no less, no more. And it's a pure right to speech. It's a pure right to speech, and there's no prohibition on a legislator characterizing another legislator's vote in Title 22, which is what I have jurisdiction over. And so I'd push back on any notion that there's any Title 22 violation for a legislator characterizing another legislator's vote. And please, if you disagree, if you find a provision in Title 22 that is a violation of that, bring it to my attention. But I just don't agree with you on that. And I think that all these mailers are in the eye of the beholder. And I think there may very well be a venue for everybody to give their opinions on it if they wish.
Mr. Chairman.
Representative Wiley. Just a moment, Ms. Duncan. Representative Wiley.
Thank you, Mr. Chairman. Mr. Secretary, now that we're in this discussion and we keep going, I was going to be quiet, but I can't. Did you ever see anything hit your desk where I voted to remove President Trump from the ballot?
Secretary Gray.
Mr. Chairman, after we filed our amicus brief, the Appropriations Committee very soon after put a footnote on our budget that said that we could no longer use state funds to file amicus briefs. That was very disturbing to me. And I can tell you personally, it felt like some sort of retribution for our filing of our amicus brief. When I think some legislators questioned that on the floor on first reading of the budget, there was a back and forth where that was discussed, and it was acknowledged by a legislator that it was related to our filing in defending President Trump remaining on the ballot and the people choosing who to elect for themselves, which I think is very important part of our republic. And that was said there on first reading. You know, in terms of this, that's the legislative history on what happened. Now, that was ultimately removed after the House voted to keep it in the budget. It was removed in the conference committee, which I think is a move that I agreed with. But that's the fact pattern on what happened.
Mr. Co-Chairman.
This has been a lot of fun. I don't see that there's a lot of resolution. I think people have to have their own standards. I will tell you that if Mr. Wiley were running against me in my district in a primary, and that mailer came out making that assertion, I would stand up and denounce that mailer, that that is wrong. And what I'm trying to say is that we all share an obligation to police this individually and to hold ourselves to high standards. So the people running against, I don't think that the mailers necessarily were under the direction of the candidates that are opposite to the ones that they receive. But I hope that those candidates would stand tall and denounce them. And I see even based on the Secretary's discourse of how that came about and the facts behind it, that seems very tenuous to me, you guys. And we are all better than that. And so I hope we would, as participants in the race, we'd not tolerate those kind of tactics being used against our opponents. I really think it's important, and that it is a subject of this committee. We are the elections committee. We are nothing more than a mouthpiece right now because there's no way we can effectuate any legislation that would be of any relevance to this election. So it's more moral suasion. I've always expected better from Wyoming, Mr. Chairman, and I look forward to having it happen in the future.
All right, committee, enough has probably been said for today on this topic. And we still do have some general public comment. Miss Agan. Miss Agan, can you hear us? You have your hand raised.
Yes, can you hear me?
Welcome.
Thank you, Chairman.
We can hear you.
Great, thank you so much. So I came in late. I was in the minerals meeting. My name is Carrie Agan. I'm a resident of Buffalo and a geologist. And I have a concern about the potential election interference from the man sitting in the highest seat of authority in this state. He put out a, oh my goodness, where did I put it? He put out, he issued a statement in regard to the Biden withdrawal. And he put the whole force of the Wyoming state government behind the Republican Party and voting for Trump and J.D. Vance. Now, how is this appropriate? How is this not election interference? Thank you.
Miss Agan, I'm not sure I'm tracking the scenario you're talking about.
It's a pretty brief statement. Would you like me to read it?
Or explain it. I'm not sure what you're talking about.
Okay. On July 21st,
And
Governor
whose statement
Gordon,
is it?
it's a press release. So Governor Gordon issues statement in response to Biden withdrawal. Okay, the governor's statement is as follows. Joe Biden's decision to step aside is a good one. However, we need to remember that the Democrats are still in control and that this administration has months to run. I am now more certain than ever we must change executive leadership in DC. I am confident Americans will make the right choice in November to vote out the failed policies of the Biden administration by voting for President Trump and J.D. Vance. In the meantime, the people of Wyoming can remain confident I will spare no effort or expense in defending your interests. How is that not the full force of the Wyoming government being used to rally us towards one candidate? Thank you.
Thank you very much, ma'am. I don't think there's anything in our election code that prevents an elected official from advocating for any candidate. And it comes down to free speech. So I personally don't see anything wrong with that press release. And does anybody else? It doesn't actually seem overly partisan. It seems somewhat courteous. And so I'm not seeing any violation of the law or any impropriety in that. And
My God.
Well, you certainly, Mr. Chairman, if I
Yes.
may pursue, ma'am, you're certainly entitled to your position, but free speech does exist for everyone, elected officials and non. So definitely don't think there's an issue there, ma'am. Not a violation of Chapter 22, as Secretary Gray has pointed out, or a libel or slander. And it doesn't violate the principles about a party weighing in before the primary because the governor acting in that capacity is not the party. It's not the official party action. There is a very specific law about parties, but there is it seems to me that parties, we now have a party candidate that's kind of been decided. So, but anyway, I don't think your idea has merit, ma'am.
Thank you, Ms. Agan, for joining us. Any other public comment that we have online? I know I have public comment in the room. Let me just see if there's anything online. We're through that. Okay, Mr. Allred.
You have Senator.
Oh, okay. Just don't talk too much. It's 5 o'clock.
I'll make this very, very quick. When we talk about this election thing, some of these flyers are going out. It used to be years ago that people would send out individual flyers on themselves. And these last couple of elections, we've seen just a flood of out-of-state PAC money, other stuff coming in and just flooding to try to influence our elections. Unfortunately, those mass flyers, a lot of them do contain inaccurate information. Some of them are accurate. But last election, there was a couple of complaints that there was a group called Western Conservatives that flooded the state with flyers against conservatives. And we found out where that money came from, and we found out who was doing it. That was before I was in the office. But then there was a complaint against a PAC up in Gillette. And we brought that up because they filed as a federal PAC. And we had no way under current law at that time to find out, the finances on a federal PAC. And I want to commend the co-chairman here because when that brought up, he took care of that. And now currently a federal PAC, if they involve themselves in a state race, legislative or otherwise, they have to file a YCFIS report. And I just want to thank the co-chairman here for that because that did take care of a huge open loophole that was being used by several groups. So that's my comments.
Mr. Chairman.
Thank you, Mr. Allred. Representative Yin.
Thank you, Mr. Chairman. Mr. Allred, do you think that the county party giving, if that reporting is correct, and that the county party gave to a PAC that gets involved in party primary races, if that reporting is correct, do you think that is illegal under Title 22? Since you are a former Secretary of State, I am asking you this question.
That's a really touchy subject. We've had people who say, if they're the chairman of a county party or an officer of the county party, can they personally donate? Yes, they can. If it was party funds, that really goes into a great thing. And as I'm not sitting on the bench, I'm not going to offer an opinion on that one because it's going to have to go to that level for them to make that determination.
Okay. Thank you, Mr. Allred. Senator Schuler.
Thank you. I really wasn't going to say anything, but gosh, I've sat here and listened to you for most of the day. I apologize for not being here the first day. I've been on vacation. And unfortunately, though, no, I should have been here to at least welcome you and, bring some rolls in or something. But I would say this, that because of this topic, I've had more phone calls and texts and emails in the last month than you can ever imagine on this topic. Most of them are just horrified by the number of mailers that are going out that have misinformation. Some of them, again, just out and out lies. Some of them, a lot of them are from out of state. That's my biggest concern, is the dark money coming in from out of state. And I think regardless of who gets elected and who doesn't, that's something that this committee, as well as our Secretary of State, as well as our AG, as well as a variety of our departments, needs to get a hold of and see what we can do about it, because people are mad about it. And I'm hearing about it. And really, I kind of would agree with the good Senator Case. I've told a lot of them, I said, it's free speech to a point, but if you're that upset, jump on board, get some complaints. I've had a couple people say they're going to file lawsuits, and I go, well, sometimes that works. It's unfortunate. We do make a lot of lawyers rich by doing that. It's better if we can deal with it in a different way, but sometimes that doesn't happen. It does change behaviors though. But, we're seeing anonymous websites, we're seeing anonymous participation on websites, we're seeing anonymous this, that, and whatever. Now, some people are actually putting their names down, some of the folks that are sending mailers around. But really, what I've told people when they've called, when they've emailed, when they texted, I said, unless it says paid for by the candidate, don't get too excited about it. Because if they're saying, and most of the people that, I have to agree, most of the people have said, well, listen, I just assume if I'm going to get a mailer, I want to know what that person stands for. I don't want to see them or hear them disparaging the other person and putting fake names and fake pictures on mailers, disparaging the candidate. It's a turnoff. And I said, I would totally agree with you on that. So I hope you'll take that on next year. Those of you that are around, I'm not on corporations, but those of you that will be around and the new ones that'll get reelected or elected, I think it's something we need to jump on board with and take care of. So that's all I have, and I'm happy to answer any questions.
Thank you, Senator Schuler. Couldn't agree more.
Let's
And
go home.
no other public comment? All right, real quick, staff, is there anything that we have given you over the last 2 days that you need a clarification on that you can't get from Senator Co-Chairman Case and I?
Chairman Olson, I don't think so.
All right, perfect.
Mr. Chairman?
Oh, Representative,
Before we adjourn, I know everyone wants to go. There is one thing I wanted to bring up. I did bring it up with the chairmans, both of you before, and I probably should have brought it up yesterday when we had the cities and counties with me. Something that might be able to fall under our housing topic, because it could be an assistance to both towns and counties, is putting the governor's grant assistance program into statute. And so I wanted to entertain whether the committee would be interested in codifying that grant assistance program, because I think it's very useful for town and counties to be able to access grants, because I know their capacity to apply for grants is really low, and we end up leaving a lot of money on the table that could be helping communities around the state do things like build housing.
Okay, there's a motion to have a bill draft. A second, been seconded by Representative Newsom. Any discussion on this bill draft? Senator Case?
Well, Mr. Chairman, I don't really want to do this, but I don't necessarily want to vote no to prejudice the issue, but our plate is so full, so very, very full. I guess I'll hang to the no.
I tried to say it was full before and you added some bills to it.
Yeah, but I got what I
Now-
wanted.
now
so-
it's extra.
so now it's
Oh,
full.
I see how it works.
No, Mr. Chairman, it's it's only till October, the poor staff.
Yeah.
And we're way over.
I'm gonna have to
Why don't you
advocate.
request as a personal bill?
Mr. Chairman, I will defer to the good chairman of the Senate committee and request a personal bill, so staff can
All right,
prepare all the bills that we have, the heavy lift we have for our next meeting.
all right, committee. With that, we will be adjourned.